Let me ask you a question. What if everything that you worked for, your career, your baby, your relationship, your home, was taken from you in a single afternoon? Not because of a conviction, not a verdict, just a form that was filed at a courthouse by somebody with an agenda. Well, that's exactly what happened to Kelsey Fitzsimmons on June 30th of 2025. She was a North Andover police officer, a new mom, 4 months into maternity leave with a baby she was breastfeeding, raising, and loving. And in the space of 20 minutes, her colleagues took her son, her fiance disappeared, and guess what? She was shot in the chest. And now she's the defendant. We're covering Fitzsimmons today. Let's get into it. Good morning, Vietnam. Hello, beautiful humans. I'm Bob Motta. This is Defense Diaries. And as always, I'm joined by my beautiful, gorgeous, really, and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all. And it is Saturday, March 14th, and we are finally getting into, as Bob said, in the most amazing cold opening, all things Kelsey Fitzsimmons.
Yes.
I mean, her baby's ripped from her arms, new mother, suffering postpartum depression, baby ripped from her arms, 4 months old. And it's been 9 months. And she still hasn't seen that baby, although the door is open for it. And we're about to get into that. But she still has not seen her child, as far as I know.
No, she hasn't. There's been a restraining order. So yeah, it's one of those cases. And this thing is set to go to trial on March 23rd. So it's here, it's happening, it's going down. And what we want to do today, and we realize we've been heads up our asses with Corey Richin, so we're a little late on this, but we wanted to chime in because we have thoughts, we have feelings, we have opinions, we have all of those things. So I figured what we would do today, I kind of want to go through the affidavit that was filed, as well as that was part and parcel, and this was filed over in family court, which oddly in Massachusetts they call family and probate. Here in Illinois, we've got
separate
those are
probate.
separate buildings, separate courtrooms.
But do we want to tell the people what we're doing after this, or are you not sure we're doing it anymore? We're all prepared.
Oh,
Are we
today?
doing a double hitter? Are we doing a double header?
I don't know, man.
Gosh, that's all my work for not.
Look, I mean, if anything, we're just pushing it till tomorrow. You're under us. You're in training though. I get it. You're in training with the 8-hour days from the trial stuff. So I kind of value having like a few hours.
No, I'm all for you because I got work to do, like actual legal work to do.
Actual legal work. All right. So what I figured we would go through. So we'll play it by ear. We'll see how long this runs, because the hearing we have is about hour 45, but we're going to be playing it at 1.25, so it won't be as long. But you know us, we're going to be stopping and talking as we go through it. So
I know us, all right.
Yeah, exactly.
So I just want to say, like this affidavit Bob's going to start with, again, like he said, it's from the family court, and but it gives the salacious details, all the parts of the story that Kelsey hasn't been able to tell. And I kind of think what it really does, for the most part, is just destroys Justin Alayan's credibility and casts him in a completely different light. I don't know that it is going to win the day in a custody case, because most of the acts predate the child, but I'm here for it.
Let's first get her a not guilty on this a single solo charge, which we're going to get into. I mean, the factual scenario is that for reasons unknown, her former partner, this cop, that's serving her doesn't have his body worn cam on. There's no footage of this. There's no footage of what happened in that room that night.
Does he have body cam? Is that normal in that?
It's fucking 2025.
I know, but some police departments
on the planet should have body worn
they
camera.
should. Yes.
Everyone. No exceptions. Every cop needs to have body worn camera. It protects them. Like, it's for everybody's benefit. No cameras in North Andover. That doesn't surprise me. Like, frankly, nothing about Massachusetts surprises me. You know, I kept hearing, you know, all the people, all our mass homies, like, oh man, it's so fucked up here. I'm like, it's fucked up everywhere. It might be a little extra fucked up in Massachusetts. It might be a little more fucked up than everywhere, because it's like you guys just have some archaic shit going on there. That's the thing. That's the thing about it. It's you guys are old timey. You really are a Commonwealth. You know, it's like I remember when we lived in Pennsylvania, I didn't understand how liquor stores were run by the government. I'm like, what? You're like, oh yeah. I'm like, wait, there's government liquor store? She's like, oh yeah. Yeah, that's Pennsylvania, the Commonwealth. I'm like, oh wow. All right. Okay. All right. So here's what this is my game plan, babe. You tell me if you want to divert from it.
Absolutely not. I don't even need to hear it.
Okay. So I think we'll do the affidavit that was in support of Kelsey's motion for further temporary orders, which again was filed in family court. But then we're going to pivot because they're intertwined, obviously. But then we're going to pivot over to the hearing, okay? Because this was addressed in some form or fashion as part of the bond conditions that were addressed over there. Yeah.
Did you want to give slight foundation just in case there's people who, you know, don't know about this case?
Beyond what? Beyond our cold open? I mean, that was like as foundational as you can get.
All right.
Did you think add to?
No.
Yeah. I don't know what you're getting at, but no. Like, I'm like how much foundation do you want?
No. Please disregard. We did do the cold opening. So
yeah, which I mean gives everybody kind of like I think if you understand the kind of the baseline of what the case is about, which I think they do from the cold open, this affidavit's going to fill in a lot of the gaps.
Okay.
Yeah. I think I feel let me put it this way. If anybody feels like when we're done with the affidavit,
they're lacking in foundational background,
we'll give you more. How about that?
Okay.
All right, let me pull it up here. Get this guy up. All right. So again, this was an affidavit that was attached to their more lengthy motion. Oh, but what I keep trying to get to, which I keep diverting myself. So after we do this, we're going to pivot over into the hearing. We're going to watch the hearing
in the criminal case
because it's important.
And
like
that's where the rule, I mean, the stay away order, the no contact order is for the baby.
Right.
That's a bail condition in her criminal case.
Exactly.
So now once she has finally overcome that, she still has to fight and go through the long drawn out process in family court, which you would hope would be expedited at this point. But
yeah, I mean, this is one of those cases where, and we talk about it a lot on our channel, where you've got this intertwining of family law, you know, the domestic violence statutes and a custody fight. And they've all been used as weapons in this particular case, and we're where we're at because of that. You know, like I'm always talking about that particular, like, domestic violence statutes are not built to be used as swords. They're for shields. They're shields. And they're really put into place to protect women, because women have just been getting abused since the beginning of time. And there was no way for them to be able to get into the courts and protect themselves until these statutes started happening, which empowered them to sometimes be able to get out of these abusive relationships. So, you know, this is one where dude flipped it around. You know,
I'd have to say there's a lot about this case that is shocking, but let's say that they believed the worst of the worst, and they still should have granted this mother supervised visitation with her child. No matter that is the most outrageous.
For the benefit of the child.
Right.
talking about a newborn breastfeeding. I mean, and she was suffering from postpartum, man. It's like everything that happened in this case is so disturbing.
Even if they believe she tried to shoot her partner, even if you okay, that happened. She's never heard her child give her supervised visitation with her baby.
For the benefit of the baby.
Right.
Like, you know, yeah,
And the
for her
mother.
benefit as well,
Right.
but
But
for
yeah.
the baby. For the baby. Baby needs mommy.
Right.
All right. Okay,
Alright, and I'm
so
sorry, but I'm gonna get water. I didn't prepare well. Sorry.
all right, I'll get started on this. All right,
Yes,
so,
yes.
I'm gonna like I said, I'm gonna start with the affidavit actually here. So again, this was filed, uh, attached to the motion, and it's Kelsey Fitzsimmons' affidavit, and there's a lot of tea in here. Allie and I were talking about this. It's like, this is a cautionary tale. You know, maybe you should be very, very careful about fucking somebody over who knows all your secrets, because this is what happens. So, all right, Kelsey Fitzsimmons here, hereby depose and stated under oath that I am the defendant in the above captioned matter and the mother of Caden Alayan. That name is just hard for me. Date of birth, we can skip that. The plaintiff, Justin Alayan, herein, Justin is the father of the child. Justin and I live together at 125 Phillip Brooks Road, North Andover, Massachusetts, between March 2024 and June 27th of 2025. I owned that home solely and individually. I sold my home located at 125 Phillips Brook Road, North Andover, Mass, on November 7th of 2025. And we all know what the conditions of that, why that happened, right? So, well, maybe some of you don't, but we'll get into it. So I have been our son's primary caregiver from his birth until June 30th of 2025, when Justin served a 209A on me in my own home. I took maternity leave to care for our son immediately after his birth, made the appointments for his pediatric visits, attended the same, grocery shop for our family, woke up with our son during the night, breastfed him, clothed him, and ensured his safety. Not a single provider has had concerns about my attention attention or caregiving or safety of my son with me. On December 23rd of 2025, I was released on bail from Western Massachusetts Regional Women's Correctional Center, pending a criminal trial on a charge of one count of assault with a dangerous weapon in Essex Superior Court. I do not believe it is in Caden's best interest for Justin to have sole custody due to Justin's use and abuse of drugs and alcohol, because I am a loving, competent mother who should be involved with the decisions of our son jointly. All right, pick it up there, babe.
I have witnessed Justin obtaining and snorting Adderall. In one such instance, Christmas Eve of 2024, and this is before the child was born, just a note, but at Justin's parents' house when I was pregnant with Caden, Justin obtained Adderall from his cousin Michael. Way to go, Michael. I saw Justin snort the Adderall through a straw in a bathroom that connects to a kitchen where I was standing.
Woo!
So and that's important details, because she's like, I wasn't like on board with this, like, hey, all right, let's watch you do your drugs. She was in the kitchen and saw this happening, you know. So next paragraph. Justin admitted to me that he obtains approximately 10 Adderall pills from his cousin Michael every time he sees him, which is approximately 5 times per year. I am prescribed Ativan to treat my anxiety. On at least 15 occasions, Justin would take one of my prescription Ativan pills when he was hungover, as he believed it would alleviate the symptoms of his hangover. I witnessed Justin taking acid in the summer of 2024. And hey, look, this is a problem because he's a fireman, and they've got very strict code of conduct as a fireman. And I think this probably explains even more why they put him on leave on Friday, yesterday. But in any event, unbeknownst to me, Justin kept a tab of acid wrapped in tinfoil in our refrigerator for months. On that occasion in 2024, when Justin was not working, I would hope so.
You never know when you want to trip balls. You know?
I mean, but hopefully it's not when you're working, Mr.
I mean,
Fireman.
I would hope not. You save the tripping balls to a weekend where you're not saving lives, right?
Like 4 days on, 4 days off.
Right. Right.
In any event, moving on. On that occasion in 2024, when Justin was not working, I witnessed Justin remove the tin foil package from the fridge, and put it into his mouth. Justin informed me that it was acid when I asked him what he was doing. I have witnessed Justin smoking marijuana. Oh no, not marijuana.
The weed.
I have recently come across video surveillance where he smoked marijuana at our home. I found over 100 such videos. Justin told me that he took hallucinogenic mushrooms with his brother, Brendan,
Shrooms.
in 2024.
All the drugs.
Brendan, she's like I am burning down the whole family. Brendan has a civilian position
on fire. Just fucking flaming it all up, baby. Woo!
In the Air Force, and he is randomly drug tested. As a result, Brendan does drugs with Justin at the beginning of his trips, usually the last 2 weeks, when Brendan knows the drugs will be out of his system before his next test. Justin told Mother, which is her, that he and Brendan microdosed after a getaway in the winter of 2024. I mean, I guess it's good that you can count the hallucinogenic events like on your hands and date them.
Yeah.
You know, I mean that's got to say something.
It's got to say something.
Not so often that you can't list them out.
I mean, my uncle back in his heyday, God rest in peace, the man took a lot of acid back in the 60s. He was prolific acid guy. You know, there's no way he would be able to count. You know, but that's back when.
He was not a firefighter.
He was not a firefighter.
He was a gambler.
Not saving lives. He was tripping on acid a lot.
Justin is a frequent customer of the Mellow Dispensary in Haverhill, Massachusetts, even though Justin is not permitted to use marijuana products in any form due to his job at the North Andover as a North Andover firefighter. Well, what you can be guaranteed is that someone at the fire department is subpoenaing the records for the Mellow Dispensary in Haverfield. They have to. They can't leave a fireman on with allegations that he is getting high when they have information about exactly where he gets his, you know. I don't know. I'm just assuming, to be perfectly honest, but I know that they can't.
Our son's a firefighter. We know that he's randomly tested.
Well,
and it's the same thing here. Marijuana is legal in Illinois. And so recreationally as well, like full legal. You know, and personally, I have a little bit of a beef. You know, look, it's still federally an issue in terms of weed. Like it's still scheduled. So, but in terms of the way that it's treated differently than alcohol, I have beef with, because they're not testing people for if they're drinking when they're off duty. Why are they But that's a different thing. That's a different thing.
Some people are writing Haverhill and some people are saying hey Veril.
Okay. Honey, here is one just immutable truth. We will never pronounce every name in that fucked up states. You know, like you guys got some whack ass.
Haverhill. All right, Haverhill.
You got some whack ass ways to pronounce shit. So just prepare yourselves mentally for us fucking up the names of towns. It's just like
I'll fuck up a lot of names.
Happen.
I'm just gonna be fucking left and right. Shit up. Fucking up.
Probably should, before we cover the trial, like try to nail down.
I mean, that would probably be the responsible.
That would probably be the responsible thing to do.
All right. Returning to the body of the affidavit. He's tripping. As a result, Brendan, okay, right. He does his drugs when he's not getting tested. Okay. Oh yeah. Hey, Veril. Right.
See, that's what happens when you correct us on the names. Now we're going to be stumbling over the names for the entire live.
Yeah. All
I
right.
still can't pronounce his last name. Alain. I think
Elaine, we got it. We
Alain.
got it.
I want to say
Justin would often ask me for cash or take money from the ATM so that there was not a financial trail of him buying marijuana.
hey,
At time,
listen, babe, slide me a 20. I
I
gotta go
mean,
edibles.
in
I can't be on the grid, baby. I
in
can't.
Illinois, you have to show your ID and
Yeah, that's and I am sure. All right. Confirm in dispensaries in Massachusetts in the chat. Let me know. I am sure they have to, you have to show your ID. You have to. There's no way. So I don't even understand how that really is working for Justin at all.
no.
Like he was just grifting off of her.
Right.
So listen, I don't want to really be on the grid. Could you give me some money for my weed?
All right. At time, Justin would purchase marijuana from Mellow Dispensary while Mother and Caden were waiting in the car. Justin would frequently smoke marijuana at our house, and there was a plethora of marijuana paraphernalia, including but not limited to a grinder, a blunt, and a pre-roll found in our basement. I mean, is
Oh,
that a
yeah.
plethora? I don't know.
I mean,
It's a handful.
the dude likes the devil's lettuce, man. You know, what are you gonna do? He's like he's a devil's lettuce guy.
Justin would typically purchase pre-rolls from Mellow Dispensary on Thursday because the dispensary has a Thursday only deal on said pre-rolls. Justin would also purchase 1/8 of an ounce to grind up and use in a bowl. She knows a lot of details about his methods of his marijuana usage. I also
Side note, real quickly. Mellow Dispensary getting some free pub here. Huh? Hey,
Hey.
hey, everybody go to Mellow. Everybody go to Mellow. Everybody
Inhale
go to
drill.
Mellow for all your weed needs. All right, there. I gave
Wow. Wow, they better send us a check. That's all I'm saying. Bob's the king of
wow.
jingles,
Wow.
but they often sound exactly like that.
What the fuck? Why do you always have to, why do you have to undercut me like that, man?
I say you're great, and then I say, but they do always.
Yeah.
sound-
Wow.
All right, I take back that last part. My
Thank
husband is the king of jingles, and you really are. And you
Hey,
really are.
thank you.
You know I love your jingles. They always make me dance.
I do know it.
They
I
put a
do know
smile on my face. I also have serious concerns that Justin is an alcoholic. Now, this is probably the most serious of her concerns. I have witnessed Justin drinking alcohol almost every night during our relationship, with his beverage of choice being 1 or 2 tall boy Voodoo Ranger beers, which is 19 ounces with a 9.5 alcohol something volume, alcohol by volume. Is that what the B is for?
ABV, yeah.
And 1 or 2 nips of the Jack Daniels and or root beer flavored McGillicuddy.
Okay, he should be fired for drinking root beer flavored McGillicuddy. That is some syrupy, sweet ass, nasty shit. I'm just gonna say that right now. Now,
I
I
don't know
quit
what it
drinking
is.
years ago, but I had a sip of that shit one time. No bueno. No bueno.
On other
And I
instances,
love root beer, so let's get that straight.
Justin would drink a whole bottle of wine I would obtain at my mother's house after Sunday dinner, which we had weekly. During Christmas of 2025, both my father and my stepfather
2024, baby.
2024. Sorry, that is an important difference since we're dealing with when the baby was or was not born.
True. I don't want people to start calling you Nestor and Lewis.
Both,
Misstating facts intentionally to sweat. Yeah. Oh my God.
both
It's snowing, by the way. What the
okay.
fuck?
Both bottles were gone in less than 2 weeks. And I recall this because my father came over during that time and asked Justin to share a glass of the whiskey he gifted Justin. But Justin informed my father that the whiskey was gone. I've also witnessed Justin's hands shaking on numerous occasions. Justin has told me his hands also shake at work, which he attributes to alcohol withdrawal. As a result, Justin has told me that he often needs to drink the cooking wine at the firehouse in order to stop the shaking.
Wow.
I mean, that is some serious shit
Stop
because you just don't break alcoholism. I mean,
I said it, I didn't mean to really say it when you're off, but this is a cautionary tale. This is a cautionary tale. And Allie's the one who said it. She's like, yeah. She's like, you want to be careful about who you're fucking with when they know all your secrets. Because this is what happens. All the dirty laundry comes out.
I'm sure that firehouse is like, damn. I was wondering how we burned through so much cooking wine.
Yeah, I mean, we use it on like 2 dishes, maybe. Like, where did all that shit go? There's Justin in the corner fucking pounding cooking wine.
I didn't think cooking wine had actual alcohol in it, though.
I mean, it's cooking. It's wine.
Oh, I guess it burns out.
It burns out as you cook it, yeah.
Right, okay.
Wait. Milo's mom. So here in the great Midwest, we say root, not
I
root.
say root.
Right. So East Coast, y'all say root beer. Over here's, we say root beer.
And what do you call what's on top of the house?
The roof.
That's not the roof?
The roof? I mean, for me, that's interchangeable.
Okay.
What do you say, couch or sofa? You're a sofa girl.
Yeah.
See, but we say pop here.
No, that's not allowed in my house. None of my family is allowed to say it.
When I moved out to Philly with you, I was converted from pop to soda. So
I will wash their mouth out with soap. That is foul.
I mean, technically, the full name is Soda Pop. So
I don't care. Just soda.
I know.
All right. So, I mean, this is a huge problem. I mean, not that, taking acid is a problem and smoking, weed is definitely a problem, but being a handshaking, full-blown alcoholic, consuming so much that you can't get through the day of work without the cooking wine.
I mean, we're making light, but that is fucked up.
No, that is no.
That
right.
is
It's all
every indication he's got a massive drinking problem.
It's all fucked up. Yes.
Which is ironic considering what he walked into the court of law
and accused his fiance of.
Flame through her about.
On some bullshit. That's why his reputation being completely like, wait a minute, he's a weed smoking, acid tripping alcoholic.
Don't forget the shrooms, which I ain't judging.
I said tripping. Oh, I did say acid tripping.
So
tripping, period.
The shrooms.
All forms of hallucinogens welcome in Justin's belly. Okay. Yeah. While I was pregnant with Caden, Justin would drink to excess at every family event or get together we attended, including at our joint bachelorette event in Maine in June of 2025. Now that's the event that he went in saying that
the event.
Yes, that's where everything that started this started.
Right.
At that event, Justin was intoxicated and kept drinking after I went upstairs to sleep. He refused to sleep to keep partying. We got into an argument stemming from Justin wanting to do more drugs. I left hours later to go home without him. So we're taking, people can just write shit, right? And that's what, and it means whatever the fuck they write. This guy must have gotten yelled at for his excessive drinking and drug use and, turned it into his girlfriend being a raging lunatic. Yeah,
gaslighter. She
was yelling at me. She was, how dare
people just being like a responsible person. Like, what a fucking rancid bitch. Wow, I better go.
She tried to cut off my fun at my bachelor party.
My God, I better go steal my kid away
That's
from
right.
her.
Yeah. On Mother's Day 2025, I took a video of Justin screaming at me while he was drunk. During the course of that day, and as a result of his excessive drinking, Justin fell in the shower, in the bedroom, and while walking up the stairs.
Wow. Yeah, I mean, which really takes us to current, because this is everything that leads up to him going into court, ex parte, which means alone, which is something that we've talked about on this channel quite a bit, because in terms of domestic violence statutes and the ability to be able to go in ex parte, you really kind of need to have it that way, because women that are trapped in relationships with abusive, nightmarish men need to feel secure in the fact that they have the ability to go into court without giving notice to that dude ahead of time because of fear of the repercussions if she's stuck in that house So you see why that exists in that way. But
right, you got to get him while he's out, and then
you got to like
cops serve him and say
court without being, having to serve him first because you're worried he's going to beat the shit out of you. So like I get why the rule exists, but this case exposes a fatal flaw in it, and it's got to be tinkered with. There's got to be ways to figure this out so this kind of shit doesn't happen. Because like Allie said, it's essentially you go into court and like typically when a woman would come in, and I'd be like in the law library and they had what they call like a domestic violence wizard where, just lay people would come in, the form would pop up, usually the law librarian would help them fill it out. If I was sitting next to them, it'd be like, oh, I have a question, I'd help them fill it out. And it gets filed that day electronically, and you're in front of a judge that day. There's always a judge that's on the bench that's going to hear these, and it's without notice to the other party. It happens without the other party being there. And then if the judge, so you're basically just making representations to the judge, and the judge has no way to dispute.
No, he's got to accept what you're saying is true.
Right.
And see if you meet the threshold. And if you do, they grant it. But they're supposed to be like out here, I think it's like 14 days that they're only good for 14 days. But I wanted to point out when you go back up to the, because I was getting my water when you did the beginning, she talks specifically about, I found this interesting. We lived together in the house. It's paragraph 2, babe. Until June 27th, 2025, which in a house that she owned solely and individually. So begs the question, why in the fuck did Justin break in with his friends? And if he's just getting stuff for his child, which he shouldn't have done anyway, but why in the hell are you turning off and disabling the video cameras? Like,
exactly.
And yesterday I put out a post like,
her computer and stealing her money. And I mean,
and yesterday
that guy is not arrested is one of the great mysteries of the world. And I heard what was said with regard to him, that he claims that he had authority to be in there. Bullshit.
From who? From who? You need to go into court and file some sort of emergency motion and say, the mother of my child is, hospitalized, and I don't have $2 to rub together to buy him stuff to tide him over until I can get in that house, officially. Yeah. But in any event, yesterday I made a post on X and I was like, well, this must be like everything he did with stealing her shit, what you just said, because they do have very strong conduct on becoming of a fireman, things at firehouses. I've represented a fireman, so I've been through this, and they're very harsh on that. But I think it's probably more now that reading this tied to this, which a lot of people commented on X, like, oh, he's also accused of like smoking a bunch of marijuana. I mean, to me, the worst of what she has put out here as far as his ability to be a fireman is the alcoholism.
Totally.
But I think this entire thing destroys his credibility and casts him in a totally different light. But so let's get to
see, and this is where it gets interesting in this case, because it's important for these types of filings to happen now, because it gets it out there. Because frankly, in her trial, none of this is coming in.
No, but some of it could. As
to him,
I don't know if it could be impeachment.
Maybe.
It could go to bias. It could go to,
But again, when you're thinking about the elements of the crime she's been charged with, it's a pretty narrow scope.
I know, but it's all. Yeah, that's true, because he's not the witness of the crime.
He's not the witness of the crime. He's not involved in it.
Yeah, so this might not. You're right. I'm sorry. This might not. He wasn't there when they served it. So
none of it.
He shouldn't even be a witness. But if he is a witness, if he gets on the stand to testify, because they want to lay the foundation of why they were in that house to begin with, this shit's coming in.
Well, the the Commonwealth would be foolish as fuck to put him on the stand.
Well, especially
Yeah,
after
like,
this.
I think in terms of what they were there to serve, which is directly related to him, obviously, because he's
Right.
the person who filed the petition. But I think they could probably get it in through the cop. You know what I'm saying?
Yeah.
I don't necessarily know that they're going to have to
They
put him
don't
on.
need him. No.
They would be the greatest gift in the history of gifts if they put him on the stand.
Right.
And I'm talking about the Commonwealth, because then this shit's fair game.
Plus what he did after breaking into the house, like all of it, because it
All
just
of it.
shows it shows his bias.
Wait a second here. So Tracy Cooley says he was in the basement when it happened.
Was he in the house when they served it? But
Was he in the
Chad, is
house?
that true?
Is that true,
I
Chad?
feel like texting attorney Melanie Little.
People are saying exactly he was in the basement, and the sister, I believe. No shit. All right, well,
All right.
let me think about that. I don't know that it changes anything.
It doesn't change much, but
I mean, because he wasn't up there to witness it, but I mean, still, notwithstanding the
some
fact
people are
that
saying no,
in
he
the
was.
house.
Oh, so some people are saying
People are
yes,
saying,
yes,
yeah,
yes.
he's in the house. Yeah.
And then other people are saying no, the social worker called. Whatever it was, you know.
Yeah, Justin was there. Yes, he was in the basement, but he didn't see the crime. All right. Yeah. So in terms of whether or not they're going to call him, I'd put a lot of money on it. There's no way they're calling him.
It'd be a gift.
It really would. All right. So do you want to switch over? So this is the temporary orders. It's pretty lengthy. Do you want to go through it?
Wait, when are these orders issued?
So this is the motion, the mother's motion for further temporary orders, the affidavit that we just read.
I think that
attached to this document.
Right. I would assume that the affidavit covered.
Let's go through a little bit of it. Let's because it has more deets. It has more deets.
All right, we should have picked one or the other.
I think this helps buff it up.
All
like
right.
For instance, here, let me read you this first one, and you tell me if you think it adds value. Okay. So mother is now residing with her mother and stepfather at 24 Oak Knoll Road. Father currently resides with the child at 28 Maple Street. Is that Stowe? Let me know in chat. I mean, like a normal person would read that word as Stowe.
It's got to be.
It's got to be. Where he resides with his parents. Father does not own or rent a home of his own. On or about November 7th of 2025, mother sold her home in order to afford legal fees for the two cases that are now consuming her world, and to pay for costs associated with her son that she willingly wants to provide. Mother agreed to put $50,000 into an account for the child, from which father withdraws funds to pay for mother's share of the child's uninsured medical costs and agreed upon activities. What activities could the baby be doing right now? Said funds were deposited into an account held by the father's counsel, and said account is being utilized in that fashion.
You mean activities for the baby? You could have mommy and me.
Well, mommy doesn't get to be with him.
Oh, so this is from which father? Oh, yeah. What? Agreed upon.
They're making it sound like a baby's doing extracurriculars.
Whose motion is this? Father's or?
It's Kelsey's.
It's Kelsey's, but father's saying he's withdrawing these money for the baby's activities. Okay, sure, Dad. I was like, wait a minute, a mom could have activities with the baby, but I don't believe that this dad is taking the baby to the mommy and me classes.
I mean, swigging off his cooking wine.
Right. He's too busy tripping balls and drinking cooking wine.
So I think it's got some background. We'll skim.
Yes, you can, babe. Motion granted.
Thank you. On June 30th of 2025, father was granted a 209A abuse prevention order against mom, as well as full physical and legal custody of the child. That 209A remains in effect, but is set for the first two-party review hearing for April 14th of 2026. The very next day, which is good. This case, the criminal case, is going to be over by then.
They're definitely going to trial this next month, next week?
Yeah. It's going to trial. So the very next day, on July 1st, 2025, father filed a complaint for custody support parenting time pursuant to MGL 209C, and then he amends it on August 8th. Mother answered the amended complaint on the 22nd, 2025, which included mom's counterclaim. The 209, while addressing custody, does not prohibit mother from seeing, communicating with, or parenting the child, which is an important distinction, which is how what happened on the 10th or the 11th happened.
Criminal case,
Right.
bond condition being lifted is such a big deal.
Exactly. Okay, so the court did not view the child as a person to protect from mother, nor did father seek such relief. Nevertheless, there's an Essex Superior Court order preventing mom from direct or indirect contact with the child temporarily, but the parties or this honorable court could modify the same upon a new agreement or order and then obtain approval from the Superior Court. All right.
I cannot say how disgusting it is for the criminal court to grant relief that the family court, that the emergency court did not grant, was not sought, and to deny even any contact. What about, I mean, the baby's 4 months old, but even if they wouldn't give supervised visitations, which to me is inexcusable. Baby could have still heard mom's voice.
Well, you remember that ratchet judge that was on
She was awful. She was awful. But the mom could have still sang baby a song, had some, obviously it's, she can't touch her and hold her, but that would have been something. The whole thing is disgusting, but not even a phone call, not even indirect contact.
That judge is an enemy to women.
She is.
Like, seriously. And thank God she's
disgusting and disgraceful.
Yeah, I mean, I'll never forget that hearing. I'll never forget that hearing where she's just ripping on Bradl, where she's ripping on the probation guy. It's like, it was so unhinged. It's like you watch the judge in Richens in terms of temperament on the bench, and you see a judge like that, and you know what judges are supposed to be. Like that dude is what you want all judges to be, no matter how irritated he might be by attorneys or things that are going on. He never loses his cool.
I would have gone into such an unbelievably deep depression. Like if someone ripped my child from me from 4 months old and she hasn't seen her for 9 months.
It's unbelievable.
You can't get that time back. That judge should be strung up by her, I don't know what, and just chastised for the rest of her life. She is a disgusting, disgraceful human being.
Tell her, girl.
And still I'm saying, believe everything you think she did. Still give her every day supervised visitation.
For
every
the
day.
benefit of the baby. For the baby. This is an infant. I mean, like we won't know until years from now, and we may never know because we don't know what you remember as a baby, but that is an absolutely critical time for a child to be with their mother. They have to be with mom.
Oh, it makes me want to cry just right now thinking about it. Like, just
all right. You weep, I'll read. So mother's criminal defense attorney, Tim Bradl, is arguing on March 12th, 2026 in Superior Court for explicit relief from any of the strictures on mother being able to freely seek orders or enter into an agreement for an order in the probate and family court, meaning without the need for approval by the Superior Court in deference to the probate and family court pursuant to AS versus BS Supra. Notably, the judge who issued that stricture is no longer sitting on the case in Superior Court. Good riddance, Your Honor. Thus far, father has been unwilling to agree to any terms whereby the party's 13-month-old child can connect with his mother, maternal grandmother, maternal grandfather, or any other maternal family members other than allowing mother's 17-year-old sister to attend the baptism of the child in January of 2026, an event mother begged father not to schedule yet so she could attend or attend via Zoom, and father refused both requests and scheduled it for January 19th, 2026. What a vindictive
scumbag
shit.
So this is how you go into family court and you say this entire fucking family is not acting in the best interest of the child.
That's
They
it.
do not care about this baby.
They don't. Because if anybody was being honest about what's in the best interest of the child, which is the standard in family court, that when there are children involved, they don't give a shit about the adults. All they care about is what is in the best interest of the child. And anybody who wants to try to make the argument that the shit that they're pulling was in the best interest of the baby, bring it.
I mean, I can't imagine, but there probably is. I mean, I don't know. Is there like a whole other side of this of people who think that Kelsey should not have been given any access to her baby?
I don't know. If it is, it's somebody who doesn't have kids and has no
It's
fucking clue what they're talking about.
no.
Okay,
And
so
fuck his parents and his family.
it's a shame on them.
Shame on
Shame on
them.
them. Like you would expect them to be the voice of reason.
Right.
Actually, grandma, like, Justin's mom. Like what? Like, honey, I really think that Kelsey needs to be able to see the baby. It's important for the baby. Like, is that conversation taking place? Or
They
is
didn't even let her parents see the baby. They deprived the whole family.
I mean, are we talking about, like, it sounds like Justin's mom is in the Adelson world.
Yeah, that's what I was just thinking. They're Adelsons.
Grandma Gotti. Yeah, it's fucked up. The limited information mother receives from father about the party's son had to be negotiated by counsel, practically begging for photos or videos of the child every 2 weeks shared through counsel. Shame on these people. Shame on these people. Like, for real. Like, it's, this thing boils down to nothing more than just a bubbling up custody fight. That this guy, again, turned around and used a statute that was put into place to protect women in order to get an upper hand in the upcoming custody fight for his kid. Just, it's disgusting. It really is. It's just, so effectively, this 13-month-old child has been cut off from his mother and her entire side of the family since the age of 4 months old. There's been no findings that the best interests of this child are being served by ripping his mother and half of his family away from him in this fashion. There is ample evidence of the effects on a newborn child when the mother is ripped from that mother-child relationship. Thank you, Tim Bradl. This motion seeks to end that travesty. On June 30th, during the service of the 209A on Mother was shot by a fellow officer of the North Andover Police, Officer Patrick Noonan. Mother was immediately transported to Massachusetts General Hospital, where she spent 53 days recovering until she was transported to the Western Massachusetts Regional Women's Correctional Center after having been charged with 1 count of assault by means of a dangerous weapon in the Lawrence District County on July 3rd of 2025. Experienced criminal counsel will refer to this charge as, at best, an entry-level Superior Court charge, rarely justifying indictment on its own, carrying a maximum of 5 years in state prison with a House of Correction alternative capped at a maximum of 2.5 years. However, here, Mother has no record and qualifies, and this is underlined for emphasis and italicized for emphasis, Mother has no record and qualifies under the sentencing guidelines, quote, assault grid as a level 2 offense in the green, quote, no incarceration zone for 1 year probation if she was ever found guilty. It goes without saying that Mother adamantly denies assaulting anyone with a firearm. All right, pick it up. Can you see it? Is it big enough for you to see?
Yeah, where did you end? At
13 there.
So I'm reading 14.
No, I
Oh.
stopped right at 13.
Home mother presents present status is that she is on GPS monitoring. She is able to leave the Mathian home for specific reasons, and it can be included that
I'm gonna guess
parenting
that is Methune.
Methune. Okay.
Like, I am no expert, though. I could be asked
Be
wrong.
included that parenting the child for appointments or exchanges can be one of those reasons should parenting outside the home be allowed. Mother has the opinion of 2 separate and independent clinicians that she is not a danger to herself or others. In the past 9 months, Mother was cleared for returning to duty after a separate assessment was completed. Huh. Mother's fitness for duty evaluation dated June 11, 2025 is available to this court and father's counsel upon request. The lack of filing the same is an attempt to limit dissemination of a sensitive document, and it will be requested that upon providing the same to this court or counsel, an an order issues that prohibits dissemination of the evaluation. As such, mother has a history of being a quality, responsible, careful, and mentally and emotionally competent person to perform her role as a police officer, protect and serve the public, and not a danger to others. On September 16, 2025, father filed a motion for temporary orders regarding parenting, custody and parenting time, child support, health insurance, uninsured medical costs, and child care, daycare costs, along with a motion to attach the real estate for child support. I this is so disgusting. And I know we talked about how disgusting this whole motion to attach real estate, trying to get her home so that the baby doesn't even have a home and instead can live with your fucking parents. Go live in your parents' basement with their newborn, you scumbag. On October 22nd, 2025, the parties filed a stipulation for temporary order on plaintiff's motion, verified motion for temporary order, which inter alia made the following provisions. And that just means some inter alia, some of the following. Provided father with legal and physical custody of the child. Ordered mother to pay. They agreed to that?
It's a stipulation. I mean, $12 a week in child support.
Ordered mother to pay father $12 a week in child support, provided that $50,000 from the sale of mother's house located at 125 Phillips Brooks Road in North Andover, Massachusetts, shall be held by father's counselor to secure mother's obligations set forth in this stipulation. Father shall maintain medical insurance for the child if and when the child is no longer covered under mother's health insurance. The parties shall share equally any and all uninsured medical, dental, therapeutic, or orthodontic expenses for the child, and the father is responsible for the first $250 annually. The parties shall equally share in child care. The mother will be prohibited from contacting father, but the father will twice per month share updates about the child and the mother through counsel. I mean, we even have, when you've got a no contact order between mother and child, that they can communicate about the children. At the time of the October 2025 hearing, mother was held without bail in a Western Massachusetts Regional Women's Correction Center. The significant change in circumstances since that time is that on or about December 23rd, 2025, mother was released from the correctional center on house arrest, awaiting to start her Superior Court trial on March 23rd. During house arrest, mother's conditions in pertinent part are to remain alcohol-free, no weapons, be monitored by scram device, reside with her mother and stepfather at their home, and that she may leave the home for medical and attorney visits. Mother's bail conditions and conditions for house arrest do not prohibit her from being with the child at the Methuen residence. Mother is hereby seeking parenting time with the child during her house arrest and after her presumed not guilty verdict at the conclusion of her Superior Criminal Court trial. At this point, mother is presumed innocent, and all facts point towards such innocence. As indicated herein, the likelihood of her being sentenced to simple probation is, even if found guilty, is extraordinarily high, and this court should consider the same when entering orders as to parenting time, as mother is not likely to face any prison time under the circumstances, which would certainly later affect any parenting time ordered now. The fact that simple probation, even if found guilty, should assist this court in allowing parenting time forthwith and increase that parenting time as the case moves forward. So what? Even if she went to prison, she shouldn't have time with her kid now? What the fuck are they even talking about?
It's crazy.
It is within this court's purview and authority to enter such orders, regardless of the order in Superior Court, pursuant to 209A, 3D, where there is a pending action in the probate and family court. An order issued in the Superior Court or District Court may be modified and, quote, superseded by a subsequent custody or support order issued by the Probate and Family Court Department, which shall retain final jurisdiction over any custody and support order. In Massachusetts, the focus is in a custody dispute between parents is not their personal rights, but the welfare of the child. They cite some cases there. In deciding issues involving custody, the overriding concern of the court must be the promotion of the best interest of the child in their general welfare. A judge shall consider whether or not the child's present or past living condition adversely affect his mental, moral, and emotional health. And they go on to say, in this case, mom was the primary care provider. The child was only 4 months old. Mother has taken maternity leave during the period of 4 months and 2 weeks, while father worked as a firefighter. Mother scheduled to return to work on or about July, or was scheduled on or about July 4th, 2025. Mother was the parent who woke up with the child, stayed home from work with the child, breastfed him, made the pediatric appointments, attended those appointments, usually with father present too, ordered and picked up medications for the child, laid him to sleep at night, rocked him to sleep when he had sleepless nights, and was a fantastic mother to the child by all accounts. Ripping mother away from child at age 4 months is not in the child's best interest. See how they worded it like that. Like we want to word it how it feels to us, ripping a baby away from the mother, but they worded it thinking of the best interests of the children. Ripping mother away, which Bob keeps saying, from this child at 4 months is not in the child's best interest, nor is continuing this chasm. Is that how you pronounce that? Chasm, right. What's wrong with me? I was like, that's not right. It's chasm. Oh God, it's like, reading sometimes between mother and child in this fashion.
All right,
There's
I'll
a very
pick it
you
up.
pick it up.
So
There's been a chasm. Pick it up.
Yeah. Chasm. So there's a very large body of developmental psychology, psychoanalysts, psychiatry, and neuroscience devoted to the importance of mother-infant bonding in roughly the first 0 to 2 years of life. Below are some of the most influential treatises, theories, and empirical findings, along with core psychological ideas behind them. I love that he's putting this in here. I mean, this is like, it's exactly what we were saying, like that
Everybody
time
knows this though.
right,
But
except
it's
for
still
Dustin
good. Right. And his parents.
Parents, right?
And
Everybody in the world
and the old judge.
and the old judge. Those folks, they weren't aware of this.
Yeah,
So
they need some training. They need some
the
education.
Indeed. The most important body of work is the attachment theory developed by John Bowlby in the mid-20th century. The core idea is that infants are biologically programmed to form a strong emotional bond with a primary caregiver, usually the mother, because it increases survival. He initially proposed a critical period for attachment formation in the first 2 to 3 years of life, later revised to, quote, a sensitive period. And that comes from simplypsychology.org. Between 1969 and 1980, it's right where I was growing up. So it'll explain why I'm all fucked up. So there were 3 volumes of the classic attachment trilogy. These major concepts were a, quote, secure base, internal working models, and maternal deprivation hypothesis. Essentially, it established that early relationships become templates for later relationships, and that prolonged disruption of the early bond can impair emotional and cognitive development. The trilogy also indicated there were long-term implications, such as the concept that the children who develop secure attachment tend to show better emotional regulation, healthier adult relationships, and higher resilience to stress. The neurobiology of early bonding has also been explored extensively. Modern neuroscience has strongly reinforced these psychological theories relative to brain development as well. During the first 2 years, the brain forms millions of neural connections per second, and caregiver interaction influences neural wiring. Infant brain development and emotional regulation depend heavily on a loving attachment to a primary caregiver. And they cite it, this PubMed, blah, blah, blah.gov. The fact that mother in this case was ripped, that's the word of the day, right? Because it's accurate. It's exactly what happened here. Was ripped away from the child so abruptly after having been the primary caregiver since birth could have severe neurobiological ramifications. In addition, research shows early bonding predicts multiple later life outcomes. Study have linked early maternal bonding to social competence in preschool and childhood, mental health and resilience, quality of later relationships, emotional regulation, and attachment style in adulthood. So conversely, severe neglect in infancy can contribute to attachment disorders, anxiety and depression, and impaired social functioning. One key question researchers examine is whether attachment disruption becomes prolonged. Attachment formation is already underway by 4 months, the age at which mother was removed from her baby boy. According to John Bowlby, infants begin forming selective attachments around 2 to 6 months of age. At 4 months, the infant already recognizes mom's voice, smell, and face, uses the caregiver to regulate distress, and begins forming a proto-attachment relationship. This stage is often called the attachment in the making phase. So removal at 4 months interrupts a bond that it is already biologically forming, though it is not yet as consolidated as it becomes after about 7 to 9 months, which the baby's still not with mommy. As such, we have now missed critical windows of attachment and should not continue this pattern.
I
So,
just need to say, this is a complete and total disagulation, this fucking case.
oh yeah,
And I honestly hate that she, by her lawyer's advice or whatever the fuck happened, chose an extra 100 days in jail where I don't understand why this motion is not scheduled until April something. I don't understand why this hasn't been happening so much faster, even since January, to get the judge to lift those the bail conditions to it's so fucking outrageous to me how much time has passed.
it's
This
crazy.
poor woman.
A year. It's good. It's coming up on a year that this baby has not seen mommy. It's outrageous. It's outrageous. I see a couple of comments in the chat. Any documents you guys ever want to get your hands on, go to Seeking Justice, their Discord channel. It's the absolute best repository of criminal filings and cases. We'll drop the link in the chat. But if you guys want to pick these up in order to be able to look at them, and what we're reading now, in case you joined us late.
Hey, it's long.
Sorry.
Oh, you were going
Sorry,
up.
babe.
I thought you were going down.
No, mother's motion for further temporary orders, which was filed in the probate and family court division. So this was filed in a different court than the criminal court, just so you're clear on that. Okay.
A lot of people are saying that it's because the first judge would not have done anything, and I guess it's the case. And I haven't been following this as closely as I could. So there could have been tons of attempts and other filings and things that have happened. I know that attorney Melanie Little has covered every piece of paper, every occurrence in this case. So
oh yeah. Hey, and by the way, make sure you like, share, and subscribe. Thank you. I forgot to tell you that at the beginning.
Yes.
Prior to a legal determination of paternity, the further court's orders a child's mother is vested with the sole physical and legal custody, and that custody arrangement continues even after paternity is established until modified by a court. Okay. In modifying custody, the court may award sole custody to either parent or joint custody to both parents as may be appropriate in the best interest of the child. So while the probate and family court, after only an initial ex parte hearing and allegations of father submitted on an ex parte basis, which means no Kelsey, no one from Kelsey or anybody representing her was at court that day. That's what ex parte means, without the other party being there. Under chaotic events, on June 30th of 2025, modified the sole custody basis with mother to father. That status should not remain. In fact, mother still has not been able to be heard on the required review hearing in the 209 action due to the pending criminal action, which put mother in a catch-22 situation by possibly affecting her criminal defense strategy if she went forward with that review hearing. It's an important distinction. We've run into this issue.
I know, but it's disgusting that she was put in this position.
Yeah, I know, but flesh that out for people so that they understand, because what they're talking about, if they go in on the 209A, if they try to litigate it, things that may have to be brought up in that particular hearing, because it's under oath, anything that's said in that hearing can be used at the criminal trial, provided that it's relevant. So, because it's under oath in terms of it's not hearsay.
But they're so disconnected. I feel like the lawyers could have said, "So what? Even if it comes out that you acted like a lunatic at the bachelor party, how does that change whether or not you picked up a gun and pointed it at a cop on the, but I can
I think
see
the
that
counter argument would be, well, she was not stable.
she was
Like
not
that,
stable.
they would lean into that.
Right. No, it's true.
Bullshit, because we're hearing the other side of it here. Like for everything that we have talked about in terms of Kelsey was based on Justin's representations. Now, finally, we are hearing the other side of the story, because as we all know, there are two sides to every story. Nothing in this world is black and white. Everything lives in the grays. Everything, in terms of
Is hers and the truth.
human beings. So, yeah, I mean, all right. So Section 10A provides a framework for the court's best interest analysis by requiring the court to preserve the child's relationship with the primary caretaker parent to the extent possible, and by mandating consideration of pre-existing parental and living arrangements. These statutory requirements neither replace the best interest of the child standard nor limit the factors that a judge may consider in determining what custodial arrangements are in the best interest of the child, quoting Smith or citing Smith v. McDonald. However, they must be considered, especially in light of the fact that mother has had to remain silent as a young first-time mother, ripped away from her child on ex parte allegations alone, so that her criminal defense strategy is not detrimentally impaired by giving discovery, testimony, or submitting to an evidentiary hearing, which could preemptively harm her defense in the criminal matter. All right, pick it up, babe.
And I just want to make sure that people didn't misinterpret what me saying, even if she did act like a lunatic at her bachelorette party. I don't think she did. I think that this is all the boyfriend being a piece of shit who she tried to actually.
Well, what we call that in the law is, we always say, assume arguendo for argument's sake. Let's say that everything that Justin said was true, which we now know was not, but even assuming that it was. So that's what Alex is doing there.
Yeah. What number am I starting with?
35.
Given the circumstances, she has had to beg for any information about her baby boy and not aggressively seek time with him on an untenable position no mother should be forced to endure simply to fight for her freedom, to be a mother, a free woman, and a free citizen of this Commonwealth. So, yeah, I mean, I see all the points that Bob you made, and that this made about how some of those issues that would have had to be raised in a hearing under the emergency order or the petitions in the family court could have bled over to the criminal court. It's just so heart. It's like, I think I would have been like, I don't give a fuck, but calmer heads prevail and say you have to give a fuck, or you don't see your kid for 5 years.
Right. Well, that's why you wouldn't represent yourself for that matter.
Right. I wouldn't even be able to think straight if my baby was taken from me. These are safeguards that can be required by this court if any concerns about mother's conduct or safety with the child exist, despite her strong record as an upstanding citizen and police officer. Mother is of solid character, serving years of service as a police officer in Massachusetts. In late May of 2025, mother was assessed by Dr. Jill Durand, a North Andover licensed psychologist, and cleared in June 2025 for return to work the next month. That's crazy. Mother's own doctors and mental health providers indicate that mother's mental health is solid and there's no concerns of her ability to parent the party's son or his safety when with her. Should a GAL be necessary for the court to assist in this determination, mother has no objection, but she would seek a speedy GAL investigation under 20 hours so that mother and child may be reunited forthwith.
Now, look, I obviously have never given birth to a child. I obviously could not experience postpartum depression. However, my wife has given birth to 4 kids, She's never suffered, like, thankfully, never say, at least that I'm aware of.
No,
If she
thank
did,
you.
she hit it like a motherfucker. But like, to me, it speaks volumes as to Kelsey's ability, that we know she was suffering from postpartum depression, which is a very real thing, and something by which you can't control. So, but notwithstanding that, she was still able to be the caregiver to her child. Where I've heard extreme examples of postpartum where mom can't get out of bed.
Or she
You
can't
know,
bond with the child either and
can't
doesn't want
bond
the
with the
mother.
child,
And
right?
those things happen. She wasn't suffering clearly that level of
Or
postpartum.
type, yeah,
Or right, those weren't the symptoms that she was having from postpartum.
right,
It sounds like she was still caring for her child in all respects.
yeah.
Father's baseless allegations alone should not be enough to keep mother from her child, given the history we have in this case and the lack of evidence to support a mother not even seeing her child again. In fact, the statute cites that only first-degree murderers should be the one exception to the presumption of shared custody or parenting time. They've got a statute on it, for all hell get out.
Charissa, uh, that's an interesting thing that I want to talk about later in this live, whether or not they should go to a bench and waive jury on this case. And I'm talking about the criminal case, obviously. It's an
No.
interesting discussion.
So the statute says no court shall make an order providing visitation rights to a parent who has been convicted of murder in the first degree of the other parent of the child who is subject of the order. So it's not even all first degree murder. It's just if they first degree murder the other child. Mother is certainly not that. Although case law instructs that where the finding of a pattern of serious incident of abuse, the judge must employ a rebuttable presumption that sole or shared custody with the abusive parent is not in the child's best interest. There is no such finding. What was the last sentence there?
Where?
There is no such finding made by any court.
Oh, yeah.
Oh, Lord, babe. There's still so many pages left. Prior to father seeking the instant
Here, let
209
let me go through. Let's see. Oh, yeah. Oh, yeah. Oh, yeah. Lot of pages left.
All right, well, we don't need the wherefore, I guess.
We
But
don't need the wherefore. Okay, so that's what they're seeking. Hair follicle testing. Mother raises these issues not to eliminate dad from the child's life. Additional drinking. Dad's a big drinker, likes LSD, microdose of shrooms.
the Ativan.
Stealing mom's Ativan, obsessing and snorting over Adderall. Let me crush up some Addy and snort it.
All right, so let's go to where we were, and we'll stop at 55.
55? All right.
Yeah.
I think we were, I don't know where we were. Deep.
Right.
Deep. All right. So this is yeah, because this is where it gets a little juicy.
Oh, look at all the
Footnotes. Oh, yeah. All right. So I think we were here.
No, we weren't. Keep going up.
Really? No, we
Oh,
were.
you're right. Okay,
Yeah.
this is where it gets juicy. All right, it's getting juicy, people. Prior to father seeking the instant 209A, there has never been any alleged abuse by mother towards a child or father. Even after the 209A, the alleged abuse was against father, not child. And that, again, is the alleged abuse. In fact, shortly before father filed the 209A, he wrote mother a card, which mother proudly displayed on the refrigerator of her home, which stated she is, quote, an amazing mother and partner. This card, however, is now missing after father broke into mother's North Andover home on July 3rd, 2025, and stole that card, along with mother's laptop, iPad, and passport. Footnote 2. Read it, babe.
It's a big one. It's a big one. Oh, that one's not big. The three is enormous. Footnote. The Commonwealth filed a motion indicating that they took a photograph of this card / letter or love letter during the search, executing the warrant on June 30th of 2025. It was days later that father broke into mother's home and stole that card / love letter.
That is fucking huge. I consider that like a bombshell. The police knew it was there. No one else has been in the home. Father breaks into the home and it's gone because he's a lying, sleazy, disgusting human being.
Low down, dirty.
Rotten scoundrel. The card, however, is now missing after father broke. Okay. The card's whereabouts are currently unknown, but was presumably discarded or destroyed by father, likely in an effort to conceal the true facts about mother as a parent. Quote, amazing. The Commonwealth indicated that they produced a photograph of this evidence in their motion of March 9, 2026, but defense counsel has not received it despite requesting same. The catalyst for the parties' relationship downfall, which led father to voluntarily vacate the North Andover home on or about June 27th or 28th of 2025, was that at a joint bachelorette event in Maine, mother and father had a disagreement in which alcohol was being imbibed by both parties. Wait, when was the baby born? When was the baby born? I guess shortly before that. And which caused mother
maybe
to
was like 4 months old, so do the backward math.
To leave the rented Airbnb early morning on June 28th, 2025. That morning, her parents picked up the child early from father's parents who were babysitting during that weekend. Father was furious about these occurrences and retaliated with a 209A. After further retaliation, and to fit his narrative, father broke into mother's home on July 3rd, 2025, broke down an entry door, and ripped out new surveillance that had been installed on July 1st. At some point between June 30th and July 3rd, it is believed that father removed evidence from mother's home, wiped her laptop of certain information, stole funds from a trip they had planned together, and more. Footnote 3.
Yeah, and look, I'm assuming you guys have seen this video. Like before he disconnects the camera, there's him either kicking or shouldering the door in, them all coming in, him and 2 or 3 of his buddies, and then they get to the camera, and it's crazy. It's crazy. So this is footnote 3. The Commonwealth filed a motion indicating that the police gave father permission to enter.
Wow.
Huh?
How do the police don't have the fucking authority
I
to
know.
give him permission to enter?
But
read the next sentence anyway.
Nothing could be further from the truth. On July 2nd, father called the North Andover police and said that he needed to retrieve his belongings at the North Andover residence, despite having no authority to do so. See 209A dated 6/30/2025. The officer with whom he spoke was under the impression that he resided there and said, well, it's your house. So, I'm assuming, you can make arrangements, whatever arrangements. There's nothing barring you from returning to your own property. We have no jurisdiction. You may be in Stowe, from what I understand, but we have no jurisdiction to say what can be removed. That's a quote.
So, and there you're saying that in a motion, in the federal court, the Commonwealth alleges he had permission from police to enter based on that bullshit? Because that seems like it is a quote from a recorded conversation.
Yeah, it has to have been.
The fuck this is how the Commonwealth just doesn't stop with their games. They just don't stop.
Game players.
They learn nothing.
They just dig in. They double down.
Oh, but it's defense attorneys y'all need to be afraid of. We have so much power.
We're so terrible.
We're horrible. We're horrifying.
Boy, oh boy, we're scary.
Oh, yeah.
So scary. Defense attorneys. We're the worst. The officer asked him if he had been in communication with their family and asked if the family was in the house, and indicated if it was his house, then he could enter. Father did not inform the officer that this is not his house and said that he was, quote, a resident of that house. And when the officer indicated she believed he had keys, father did not correct her, as he clearly did not have keys. Father then called the police again on July 30th or July 3rd of 2025, and the father led the police to believe that he resided at the North Andover home. It is clear from the video surveillance that father had no key and busted through the door to enter. Father indicates that he was going to North Andover to retrieve his belongings and that he had, quote, full authorization to be there. The fact is that he had no authorization to retrieve his belongings, and the 209A did not check box 10 to allow such retrieval. The officer indicated that no one could be there with him on July 30th and only call them if something escalates. What'd you say?
July 3rd.
Oh, July 3rd. He provided no documentation or authorization to enter the North Andover home. He also made clear that he would not pay for a detail. He told the officers her family had already filed, quote, negligence against him.
What the fuck does that mean?
Well, they already filed negligence against me.
The fuck? What's that mean, bro? What is that? Is that a real thing? Did you just make some shit up, bro? And that was not true. In a later,
I don't know how it could be true. I don't know what
they filed some negligence against me.
Is that some more fucked up Boston or Massachusetts shit?
Hey, they filed the negligence.
Dude just made some shit up, literally. In a later audio the same day, father threatened the police that he would go to the media about the police not assisting him to go into the home. All right, good luck with that, bro. Have a good day. Go to the media.
Because why exactly?
Into your fucking ex's house, man.
If you're so damn broke that you can't buy your own fucking diapers and a week's worth of clothes that then your mommy can wash, then I can't help you, buddy.
I mean,
they're way underpaying firemen, I guess. Spend less money on acid.
I mean,
alcohol.
Our son makes a pretty good living. He's a young firefighter.
I know. That's what I'm saying. Well, then, either they got to pay him or you got to buy less at the dispensary.
Oh, he did go to the media? Wow, what a fucking moron. The recordings are available for the court upon request. A copy of this surveillance video will be provided to the court upon request. Father clearly, forcibly broke into the home.
You, I think, moved on past 3. You were so
No, it was 3. That was
okay.
all 3.
On July 3rd, 2025, while Miss Fitzsimmons was hospitalized and fighting for her life after being shot in the chest.
I'll be right back.
Father was caught on video surveillance, forcibly breaking into mother's Andover residence with 3 other accomplices. Footnote 4. Well, 3 and 4, but we'll have to wait till Bob comes back. It is believed that he was either taking additional evidence or returning the items he had previously stolen, as mother's laptop and iPad were returned, but wiped and accessed by Justin C. Paragraph 47 below. The surveillance was also destroyed by father that day. Father admits that he did not reside at the Andover residence as of June 27th, 28th, and that he lived with his parents in Stowe, Massachusetts. Therefore, as of June 27th, 28th, it was clear that father had no residential or possessory right whatsoever regarding mother's secure, locked property. Mother had, and always had, sole ownership of that residence, and father, by his own admission, no longer resided there on June 30th, 2025. I'll read slower because we're almost up to where Bob has us. Mother's father is an alarm and surveillance contractor who, on or about July 2nd, 2025, had just changed the locks and updated the surveillance system on mother's North Andover residence after father unexpectedly and surprisingly commenced litigation against mother and took their son from her. So, and that's where we shall pause until my husband returns. Let's go to footnote 4 before we.
All right, a copy of the surveillance video will be provided to the court upon request. Father clearly forcibly broke into the home.
Okay.
All right. Oh yeah.
And then right, so I was at 45.
Okay.
And that gets us to footnote 6. So I guess read 5 and 6.
Oh, okay. So five is father's affidavit of care and custody dated June 30th, 2025. His complaint dated July 1 of 2025, and his military affidavit dated July 1, 2025. And quote, lived together as of a few days ago, end quote, putting last residing together as of June 27th or June 28th of 2025. So
Yeah,
mother
that resolves that fucking question, asshat.
question resolved.
Right.
So mother and her father have both submitted sworn statements outlining father's breaking and entering in pursuant to a motion for disclosure of promises, rewards, and or inducements filed in the Essex Superior Court motion on February 25th of 2026. These statements can be provided to the court upon request.
Okay. Mother's, oh, right, we did that, right. After gaining entry to mother's residence, father went into the basement and disabled and destroyed the surveillance system mother's father had just installed, causing thousands of dollars of damage. Additionally, the modem power was forcibly pulled out of the wiring by father and his accomplices. I mean, what about that for a charge?
It gets fucking worse. This guy is in some nefarious shit, stealing all her money, changing her the shit that he did. How he has not been arrested is just absolutely disgusting and mind-boggling. There exists no valid excuse in the world as to why he is not arrested.
Especially given the receipts in paragraph 47. While in mother's residence, father stole cash, gift cards, mother's passport, her personal laptop computer, and other valuables. After stealing mother's laptop, father brought it to his parents' residence in Stowe, Massachusetts, where it connected to the Alain, is that what we've decided? Alain family's Stowe Wi-Fi.
Alain, I think it's Alain.
Alain. Yeah, you're right. Alain. Braceland 4. Oh, is that funny? Is that like Graceland?
I don't know.
I don't know what the fuck that is. From there, father accessed mother's Facebook, AOL, and Gmail accounts, gained entry to her bank accounts. He then withdrew approximately $5,000 from their joint account. I mean, practically liquidating it, closed accounts, accessed her medical records and her pension beneficiary documents. Further, he canceled the party's travel reservations, redirecting those funds to his own accounts. All of these actions were traced and readily apparent on the laptop recorded computer library.
Yeah, computer history.
I was like,
I saw you train it.
Library.
Oh, scrolled too fast.
Subsequently, father returned the laptop.
Is the mother's maiden name.
Oh. Subsequently, father returned the laptop to mother's house at some point during her 53-day hospitalization in what had to have been another unlawful entry, an obvious effort to conceal the computer crimes, but for which he knew he would not be caught after dismantling the security and surveillance equipment on July 3rd. This conduct is not the conduct of a man who is acting in good faith, simply protecting the party's child or trying to co-parent. This is the conduct of a vengeful ex-fiance who is trying to punish mother for arguments
with
possibly
great vengeance and furious anger.
Possibly embarrassment he sustained at their mutual bachelorette party in front of dozens or more friends and family, or possibly even his own regret for his upcoming nuptials and placing blame on mother rather than his own decisions. How dare her call out my drinking in front of my friends?
If I want to get down,
I want to
get down. You don't say shit about me getting down. I mean, is that what this boiled down to? She was calling him out on his bullshit.
I mean,
hey, Justin, you're being a drunk fuck, and I want to go home and go to bed.
I could give a shit, actually, less what she did. She could have done everything he said, and she still should be with her fucking child right now.
True story. True story. This doesn't have jack shit to do with the baby in terms of what happened that night.
No.
There's no evidence whatsoever that she's done anything other than being a loving mom to that baby.
This matter does not involve two parties who never were able to agree on medical issues for the child or religious issues for the child, on education for the child. Rather, the parties always agree on such matters relative to their son. Shared legal custody is defined as a continued mutual responsibility and involvement by both parents in the major decisions regarding the child's welfare, including matters of education, medical care, and emotional, moral, and religious development. Father cites no situation where the parties disagreed about the matters for their son. In reality, the parties simply no longer get along and their engagement ended, but resulted in a child they both now need to parent. Although there may be some conflict between the parties, joint legal and physical custody may still be appropriate if the conflict concerns the parents' own relationship rather than being about specific areas of disagreement regarding the child's care, custody, and upbringing, and they cite two cases for that proposition. While the feelings and the wishes of the parents should be disregarded, the happiness and wishes of the child should be the controlling consideration. So they just go on to discuss the law and how it should be applied, and that, you know, I think we can. And then it gets into
Yeah, I think we
so
can
we
do
can
it.
just say juxtaposing, we can read 54, juxtaposing father's lies, baseless allegations, and obvious illegal activity against mother's conduct wherein she has never harmed the child, threatened to harm the child, or been under the influence of illegal, non-prescription drugs while in the child's presence. It is obvious that mother should at least be allowed to parent her new baby, much less also share in the decision makings with father. Mother is clean, drinks no alcohol, uses no drugs, and is in the care of a mental health providers. Notably, father did not even allege mother had done anything to the child in his own affidavit obtaining a 209A, made no threats or was a threat to the child, except insofar as he alleged she had punched her own stomach at some point during pregnancy. But clearly, mother did not do that, as the child was born perfect and healthy. On the other hand, father has consistently abused alcohol in the presence of mother and after child birth and after the birth of the child child after birth. Oh, in the presence of the mother and child after birth. And on more than one occasion, mother witnessed father taking non-prescription drugs he received from his cousin and or took from mother's prescription bottles. Father regularly smokes
Lines of crushed Addy.
Father,
Oh, yeah. Oh,
father
yeah.
regularly smokes marijuana and drinks during his working hours. Smokes
Oh,
and
boy.
drinks during his working hours.
Oh,
Mother's
boy.
recently discovered on the North Andover home's video surveillance that father's use of marijuana was far more prevalent than she had understood and what she observed. There are over 100 videos of this use by father, all of which is available upon request.
I just hate him. I hate him. I hate him.
All right, let's go to the bail hearing.
Okay, you want to do it?
I want to do it.
All right. Do you want to do all right, so you don't want to, like, is your preference not to go? It's not only a bail hearing. I want to be clear about this. This is the final pretrial, which, if you're new to court proceedings, it's the last court date before trial set to start. So every case has it. It's where you typically go through whatever motions in limine have been filed, and or as some like to call it, motions in lemonade.
I know that's a cookies thing. I mean, a cupcakes thing. That's Melanie Little.
Oh yeah. Oh yeah. All right. So the sound is not great on this. For some reason, I'm not seeing the boost. I don't know why.
Oi. Oi.
Oy vey. Oy vey schmear. All right. Let me see. Okay. Let's see if we can get. But we do have the captions.
Does the Commonwealth intend to call?
Let me see. I'll try this boost. I don't know why I don't know why the other boost isn't showing up. Like our typical.
Is this not on YouTube?
Yeah, it was on YouTube.
Makes no sense.
It's Boston 10 shit. It's weird. Strange. All right.
Mr. Elaine at trial? Yes. Okay.
Wait. He just asked, wait, boost, go forward. Are you calling Mr. Elaine at trial?
This is the very beginning of the hearing.
I know, but
lost it.
they just said those words.
What do you want? What do you want me to
Go
do?
forward 10 seconds.
Forward or back?
Back.
Okay. Bloop bloop.
Okay.
Okay, there you go, little buddy.
Related to Mr. Elaine.
Elaine, that's correct.
Elaine, is that right? Okay. Let me just say, I did have a couple of questions for you folks before I turn it over to you, Mr. Bradl.
Sure.
Does the Commonwealth intend to call Mr. Elaine at the trial?
Yes.
Okay.
Woo!
All right, so I guess a couple of observations, Mr. Bradl, then I'll turn it over to you. One is that your affidavit in support doesn't mention Mr. Elaine at all. So I'll just point that out to you. Also, the proposed order doesn't mention him either, or who the subject of the records would be that would be ordered to be produced.
I forgot we're going to do this at
And
1.25.
also, essentially, if I understand this correctly, and I did review, there was video footage that you folks dropped off last night, or at the end of the day, I forget the other contract open, but I did review the video footage. But if I understand, generally speaking, that there's these multiple instances, if I remember correctly, in April or in May of 2025, where Mr. Elaine is observed on this video, I assume at their residence at the time, smoking marijuana or something.
Yes, Your Honor, that's what we would allege.
And so, and your argument is somehow this could be relevant to Mr. Elaine's ability to perceive the events and hear the events accurately and then convict related them. So, but how is, let me ask you this, marijuana is legal, right, in Massachusetts, as is beer. So if the video displayed him, Mr. Elaine, drinking a glass of whiskey or a beer, the number of times that you saw him.
What's the difference?
Right, what is it?
Happy to answer, Judge. So in this case, the state of the evidence is that we gave you 4 or 5 clips as a representative sample of over 200 clips that we have that are similar over a long period of time. And
in other words, 200 instances.
maybe 270, I'm being a little conservative, but over 200, let's say.
All right, over 200 instances of.
What you see in the representative sample.
Okay, and what was the time period?
So the time period would go back probably a few months, Judge.
A few months before the June 30th incident?
Correct.
Okay,
Correct.
all right. And this is something that has been produced to the Commonwealth?
Yes, we sent them, and actually we got it from the surveillance that the Commonwealth had, that they returned to us recently. So
Okay.
they definitely have everything. And so Judge, it's fair to say that there's a pervasive marijuana use by this guy.
Okay.
And I understand, your point that marijuana is legal in Massachusetts. It's illegal under federal law, number 1. Pages 37 and 38 of the town of North Andover policy and procedures have a very comprehensive anti-drug policy for all town employees, which my brother and I were just discussing. It's a public document, and it prohibits any drug use on town property, prohibits any showing up to work under the influence of any drugs, no smoking. There's also a statute.
But what's the evidence? I get all this. I certainly understand. And I certainly understand that there's plenty of legal substances, including alcohol and marijuana, that would absolutely affect a person's ability to perceive and recall and et cetera, and testify credibly. But what is the evidence that on June 30th, that whatever time in the morning it was when this incident happened, that Mr. Elaine was under the influence of something at that time?
So Judge, it was the afternoon, and the idea is that, the pervasiveness of the usage raises a legitimate question. And this is a discovery question. We're not talking about an admissibility question at this point. We're just talking about a discovery question. And I would venture to say that the standard there is something.
I'm sorry, Steve.
Yes,
sorry. But the case law is clear is that this can't be, I just was reading Commonwealth versus Jones, I think, which is clear that this can't be, Rule 17 can't be used as a discovery tool. It's a tool to make the trial more efficient. In other words, you have to show that the evidence would be admissible.
Yes.
Right? So.
Well, I mean, it sort of is a discovery tool in the sense that we get the documents early. And in order to get the document showing, we have to make showing. And I think the showing is made, Judge, in terms of relevancy of his ability to perceive and recollect. That's something that's always relevant. And so we have documented video of him smoking marijuana all over his home all the time for months, over 200 times. And so the pervasiveness of it, I would suggest, points to that there's a problem, number one, certainly a problem with this guy. And number two, Your Honor, that there's likely to be overlap with his work schedule as a firefighter, where it would certainly come into contravention of town policy, which is page 3730 of the town policy, which prohibit showing up to work under the influence of marijuana. And that would trigger the further town policy, which is that if there's an incident, there should be random testing of town employees. And so we think there's a good faith basis.
Babe. Babe,
We
it's
know that he
frozen.
was beyond what's being said here. We know from the
Oh.
affidavit that he was drinking cooking wine at the firehouse.
Well, it sounds like the judge is more focused on it doesn't sound
Rule
like he made it
17 mechanics.
right,
in
but
terms
no,
of-
no, but my point is that and you guys let me know how the sound is because I turned my sound up so I could hear this and I turned my mic down, but so if I gotta turn it down more. Because I still sound pretty high in my ears. But anyway,
I
that
crank
they're
mine down to 50 because I
they're
have
focused on saying how this would affect his ability to perceive and remember and recall the events. So that kind of bias with his testimony, not challenging him, in general. So that's what the judge is.
contemplating.
Yeah.
To say, give us this early, Your Honor, that if he's been tested at work and he tests positive at work, he's been given breaks at work, he's been put in rehab at work.
But how would that be admissible? So that would,
So
let's assume even 2 days before, on the 28th, his screening came back at his employer for positive for THC.
sure.
Okay, so then what?
So I have a good faith basis to ask him on the stand, were you smoking on when this happened? Do you remember these events accurately? Were you, do you even know what you were doing when you were in that basement? Do you're taking your baby under the influence of marijuana?
You don't think you have that good faith basis to ask that question now?
Well, there's always,
200.
I don't need to tell you, Your Honor, trial lawyers are worried about when the guy says no. And that's why it's a discovery matter in terms of, ultimately it'd be a discovery matter to get the stuff. But, the lawyer is always at the mercy of someone saying no. And then if you have the backup, we can, as we say, we can prove it up. So it is relevant in that respect of us needing to know how pervasive his marijuana problem is. And we have pretty good evidence, times 200 and whatever, that it's a pretty pervasive problem. And so I think it's probably meets the relevant.
Who the fuck takes 200 videos of themselves smoking weed? Is that bizarre? Like what? Every time this guy fires up, he decides to take videos of himself blasting on a joint. Hey, dude, watch me roll up this blunt, bro. Oh, thank you. Allie's like, it's the surveillance, jackass. I'm like, oh, thank you. That makes more sense.
Standard, the lack of fishing expedition. We can't get this material anywhere else. This is something that is important to make sure the cross-examination is appropriate and can be proven up. So I think my good faith basis kind of comes from being able to prove it up. And that's one way I can do that. I always have in mind, Judge.
Again, I'm not sure that the record, again, the balls and strikes that I'm being asked to call in this narrow instance under Rule 17 is keeping in mind that you're asking for me to order production of records, of employment records. Again, I'm not seeing how that has any materiality or relevance to what his state of mind was, Mr. Elayden's state of mind was at the time of this incident.
Well, I think you gave me my answer. When, maybe there is something in there just right up against this incident. Maybe he was under monitoring. Maybe he was reprimanded for coming in smelling like marijuana. Maybe he, had some marijuana at the fire department. We have to look at the records. I don't have a magic wand when I say, exactly what they might have, but I can point to relevancy and materiality and lack of fishing expedition by saying we have 200 something instances of him doing it over a few months. That creates the likelihood that there's some overlap with work. And then, okay, so then we have town policies, and then there's also another law, Judge, that's Chapter 40, Section 101A, It prohibits hiring of firefighters who smoke for pension purposes. The Commonwealth doesn't want to get into smoke or fire. So,
Mr. Gray,
I mean, 200 occasions over 3 months. Dude was smoking a fuck ton of weed. I mean, that is a lot of weed. I mean, I got some friends that love them some weed, but that is a massive, like, I've got the friends, you know, if I get an edible, I do like a 5 milligram, because if I do a 10, I'm like floating in outer space. I mean, I've got friends that can do 50, 100 milligram gummies. And I'm like, what? I'm like, what? I couldn't even function as a human being on this planet if I ate 100 milligram gummy. I'd be out of my mind. Like I would just like, so that much smoking in a 3-month period. I mean, it's every time he steps out of the house, he's blasting a joint. Or as Melanie calls it, reefer, which I love. It's like the old heads call it reefer. Like we call it reefer. Mary Jane, devil's lettuce. I mean, he's definitely a fiend. He's a fucking fiend.
all of these statutes that, again, I don't take issue at all with, I asked that rhetorical question to start with, but I don't take issue at all with the notion that marijuana can, and especially something that's smoked off, and can affect someone's ability to perceive and then relate what they saw and heard. It's the idea of getting records that you are efficient for, arguably, not because, hold on, again, I'm constrained because the case law says that this is not to be used as a discovery tool. Now, let me say this, I've been there before, and I know that you're between a rock and a hard place, because you have some information like you do about the possibility that they'll be in the records, but the SJC has made it clear that they need more, I believe.
so you're the judge and I respect your ruling, but I should just say,
But I haven't ruled yet. So
I appreciate that. My thought is that whole business about it not being a fishing expedition, I think that what they mean there is that you can't be held, the defense can't be held to the standard of knowing what the other people have without getting to it. It would be easy if you could say, I know they have 16 reports from 16 days that he showed up smelling like marijuana and stumbling around. But, you know, that's never the case, because this is adversarial litigation. And so we don't know, and we never do know. So the courts can't put the defense in this catch-22. We have to ask for the records, and it can't be a situation where, you know, you have a time machine, you have a magic wand, whatever you want to call it. You know, we don't know. Defense counsels never know. And that, it can't mean that Rule 17 means nothing. So you have to interpret this fishing expedition thing as meaning just completely throwing darts. And so what I answer to say why we don't have a fishing expedition here is because, excuse me, we have this incredible number of video documentation. And we know that he's a full-time firefighter in the town. And so the likelihood of an overlap is pretty substantial. So that's really all we have. And that's all the defense counsel can ever have is kind of skirting around the edges.
And in fact, you know, arguably, you have more than we often see.
Yeah, they call that circumstantial evidence. It's what the state, the government tries almost every case on, circumstantial evidence. This guy in 3 months is caught on surveillance video in a 3-month period of time, smoking 200 plus times. Circumstantially speaking, I don't think you need to take a giant leap to think that he was indulging at work. I mean, that's what circumstantial evidence is. You know, you go to sleep, you look out your window, there's no snow on the ground. You close your eyes in bed, you wake up in the morning, you look out your window and the snow is covering your lawn. You didn't see it snow, but the circumstantial evidence is very powerful that while you were sleeping, it did in fact snow. Same shit.
Right? I think so, Judge. So, you know, this is just, you know, this is asking for records that will potentially be able to give me the ability to prove up a denial, I think, if you will. And, you know, who knows what he's going to say? I don't know, because he's an adversary. So I'm just trying to get the record as populated as possible. And if I have information, I'll know the parameters of what he's saying is truthful and what is not truthful. And I think it would make for a better cross-examination and a more economic cross-examination if I'm not dancing all around without the benefit of these records. So that'd be my argument, Judge. Thank you.
Well, I think I just echo much of what you said, and so I hate to do that, but, and echo what he said. He said, maybe, we don't know. That's the definition of a fishing expedition. That's the definition of a discovery tool, if that's what he's looking for. And if he felt committed, he has a basis to ask that question. He could ask the witness on the stand, were you under the influence, or had you smoked, or anything like that. He has a good faith basis to do that. I wouldn't object to that question. I think it's a fair question based on the landscape that we have here. And the answer is what the answer is.
Oh yeah, I'm sure Justin will be on the stand admitting that he smokes blunts at work. Come on, dude. Come on. I mean, you kidding me? Yeah, he does have tiny hands. Oh, but Your Honor, I have to make the following argument with my tiny hands.
Is, and that's often the case. So I would suggest you, he has not met his burden, and the court should deny the motion.
No, Your Honor, thank you.
No, I'm not.
No, that's all I have for that. Yes.
So I'm going to issue a more formal ruling later, but the motion is denied because the defendant has not met her threshold requirement under the Limine protocol. And as I said, I'll be more specific in my written ruling later. All right, now that's moves us to.
Frankly, that doesn't hurt Bradl at all. The judge is going to let him get into that when they call him to the stand. You know, I mean, and people can take for the, if they decide to do a jury as opposed to a bench trial, like, don't worry about that judgment is what I'm telling you. They're going to let Bradl dig in. He's going to get to ask the questions. Somebody's credibility. I mean, let me put it this way. If Bradl asks the question, you know, relating to him being caught on surveillance 200 times, smoking blunts in the backyard. I mean, do you think any jury and or this judge is not going to make the logical leap that he was probably smoking at work? That there exists at least a very distinct possibility that this bled into his work? Because you're on for, you know, it's a shift at the firehouse. You're on for days, on days, off days. This isn't an 8-hour thing. You go home. And I'm here to tell you, you know, there's been a long-standing debate as to whether or not marijuana is something that you can become addicted to. I'm here to tell you, you can become addicted to marijuana without question. I mean, if you're using it to self-medicate, and when you're smoking that much, I got news for you. You're self-medicating. There's absolutely no question about that. Anytime that you are doing things to excess like that, whether it be drinking, whether it be marijuana, whether it be hardcore shit, you are self-medicating. You've got deeper seated issues that you're trying to get yourself through by being medicated, whether it be weed, whether it be scripts, whatever. I mean, if you're abusing anything and it's not been prescribed, you're self-medicating. That's what it is. And that's what's going on here. Which goes to his credibility. And frankly, if I'm on the job with him, I'm like, what the fuck, bro? Like, I'm going into burning houses, man. Are you putting my life at risk, bro? Because you're a fucking stoner? It's a
Well, and that's
legitimate
what I
thing.
wonder, if they think this judge wouldn't allow them to cross-examine on that ground, like to impeach him on that.
Well,
like on
impeach
just
him
in
is one
general.
thing. He's definitely going to let him ask. He's going to
Well,
definitely
he's going to let
get
him
into it.
ask to the extent that it could have affected his ability to
Remember and recall
perceive-
what was going on that day.
right, but
on the
not
day.
like, well, you're the kind of guy that violates the, you know, the rules of being a fireman and just
Maybe.
uses drugs anyway.
I
But I'm
wouldn't get
assuming
into-
that's why they're not raising that as a potential grounds for this.
Well, I think that problem is going to be the thing that we were talking about before we started watching the hearing, which is the relevance. I mean, you have to, there has to be a relevance nexus as to how it matters in terms of what happened up in that bedroom. You know what I'm saying? It's like, but it's all intertwined. Because I mean, you can't get to being up in the bedroom with her being served without getting into Justin and how
Well,
it
what if
ended up
they
being
asked
that
for
day.
any records where he was
Because I
found
think
to be
I think
lying?
I would make the argument it all goes to Kelsey's state of mind. You know, she's sitting there on that day, the day that she gets served, minding her own fucking business, taking care of her baby, and she gets body slammed. Like these cops just show up at their door telling her we're taking your baby. So in terms of like her state of mind at that point in time, I think a lot of that is fair game in terms of how they got there. Meaning that she would have had no reason to know or to believe that Justin would be capable of doing something like that to her. You know what I mean? It goes to her state of mind of like where she was at mentally up in that bedroom in that moment in time. Like I would be beside myself. Be like, wait, you're taking my baby from me? What the fuck is happening here? You know what I mean? It's like, I don't know. It's going to be interesting to see what they allow in, what they don't.
She probably threatened him that
I
night.
thought we would then go to the defendant's motion in limine, which has various requests. Let me just get from the paper 67. Now, you know, I meant to point this out before we started on the Rule 17 motions, but
Oh yeah, when we get into the family court, the custody battle, this shit's all fair game. What do you mean? What is that weird
I don't know
headline?
about the stuff that predates the birth of the child.
What do you mean? This is all like after the kid.
Oh, that for sure.
I mean, like all the allegations that we have seen, I think, are post birth, right?
And that affidavit, a lot of them were before the baby was born, during pregnancy, 2024.
I think that's relevant in the custody fight. I mean, if you're
The
trying to show
alcoholism
somebody's got,
is.
why is that? But the drug use isn't. It's the same concept.
Well, not like the occasional acid. I took acid. I did, but
Okay,
maybe that
fine.
extensive marijuana use.
You
That
know how
probably
the
would be.
courts view any kind of drug use, whether it be the occasional acid trip or microdosing on shroom. You know how courts are. You know how the family courts are with that shit. I mean, you and I both know that probably doesn't impact anything really in the real world.
Oh,
But in
the
terms of the
acid
court of
was
law,
after the baby. Acid was in the fridge when the baby was born.
there
Oh
you
no,
go.
no,
Oh yeah.
oh,
Oh
that's
yeah.
an issue.
Got some dripping wet acid in the fridge
Just
there,
in the
buddy.
fridge with the baby stuff.
Oh, it's right next to the frozen breast milk right there. Don't get my acid on the breast milk.
I'm making scout lunch, so I'll be back.
I think it's worth saying. So, Mr. Bubatosi, at the last hearing, you said this is something to the effect of, and probably more eloquently than I can remember, but something to the effect of that this is a very simple case, straightforward about what happened in the bedroom. And I'm glad to see that the defense seems to agree, because in in this particular motion, Mr. Bradl, you wrote, the narrow issue here is whether Ms. Fitzsimmons committed an assault with a dangerous weapon against Patrick Noonan on June 30, 2025 in the bedroom, et cetera, et cetera. So I point out that you folks agree. So that's my thinking here, in trying to keep things simple when I'm addressing all of your motions and your trial motions and your requests. I agree that we at least have an agreement on a starting place. But let me hear you, let me ask the Commonwealth on the defendant's motion. So as for sequestration, let me say this, I typically don't issue sequestration orders like formally. In other words, I would ask the Commonwealth. I would just rely on if there's an order in place for you folks, both sides, to tell your witnesses how it works. So does the Commonwealth object to a reciprocal sequestration? In other words, yes. Sorry. Okay. Thank you. So I'm going to allow the request that the trial witnesses be sequestered as that term is used in your motion, and it will apply to both sides. So I would, you'll be responsible in conveying to your witnesses that particular order that they're not to discuss their testimony with other witnesses. All right, and on number 2, the opinion terms. So I almost always use people's names, their surname. It's very possible, if not probable, that I would use a term like alleged victim, who I believe would theoretically be, not theoretically, would be Officer Noonan. Thoughts?
The Commonwealth has no objection to number 2, so long as it's also is binding on defense counsel.
Meaning what?
He also not refer to anyone as victim, suspect, target.
Right. So are both sides okay with alleged victim?
Yes.
Yeah, of course, yes.
Okay. All right. So I'll allow that, and I'll write this up later so that we're not. And number 3 is basically a motion to preclude prior bad acts or other acts. And let me say this: it probably makes sense to hold off on this because I view this as an opposition to a couple of the Commonwealth's motions, I think. So just remind me to straight and circle back if I haven't addressed everything.
Certainly.
In there. Number 4 is voir dire. Let me hold off on that for a moment because Commonwealth also has voir dire, proposed voir dire. But let's go to number 5, which is the last. So number 5 is that the court exclude. There's a lot there. Commonwealth.
I mean, I think most of it is not really applicable to the facts of this case. So insofar as, the defendant is known to other members of the North Andover Police Department because she was a North Andover police officer, I think that's kind of unavoidable. They're
not a repeat offender. That's what I'm.
Certainly not repeat offender. And I think the defendant did never fled anywhere. She was never a target of any broader investigation. So I think as this is somewhat boilerplate, it doesn't really apply to the case, so there's no objection.
All right, so that will be marked as allowed without objection. And we really should at some point talk about, and this may arise during the hearing on one of your Commonwealth's motions, but talk about the scope of what the evidence will be as it relates to this 209A work, right? And I think we need to flesh that out, or maybe it doesn't need to be fleshed out. But we'll get to that in a moment.
Flesh it out.
So that leaves
I want to hear it.
paragraph 4 in the defendant's motion, which is request for voir dire. And while I'm addressing the defendant's request for voir dire questions from jurors, let me take the Commonwealth's out. Paper 63 is the Commonwealth's request for jury questions. So let's just go.
All right. Just to catch you guys up. So the defense filed kind of an omnibus motion with a bunch of its motions in limine included within it. The judge is going through them one by one. Currently, he's handling questions that the defense wants to be able to ask a jury during voir dire. Okay, so that's what they're going through right now. And the first 3 were other short motions, 2 of which he kind of glossed over. He does want to get into how much or how little of the 209A stuff is going to come in. That's obviously Justin going in and getting the restraining order ex parte, how much that's going to be allowed or how much of that's going to be allowed in the criminal trial. So this is what we're dealing with now, voir dire questions to the prospective jurors.
Back for a moment. Paper 63 is the Commonwealth's request for jury questions. So let's just go back for a moment. As I said, I intend to handle this impanelment like I do all impanelments, and that is to use a case-specific juror questionnaire in addition to the single-page questionnaire that the jury commissioner issues with the summons. So my philosophy is, and also you folks will have, we will conduct individual voir dire of every juror, whether they answer yes question, any of the questions or not. You folks will have permission to ask reasonable questions as part of attorney conducted voir dire. My philosophy is to.
I'm going to have this conversation when Allie gets back on, because it's a very interesting question. It's a very, very interesting question. And as an attorney, I always felt like if it was an issue that I felt really required some knowledge of the nuances of the law, like more so than your typical charge. And here, when you're talking about an assault, which is really perceived, like an assault is different than a battery, because assault is something that someone perceives. And in this case, we know there's no body worn cam. So we literally have a situation where it's he said, she said as to what happened in that room. But again, the assault aspect of it is what Noonan perceived. He's claiming he perceived that she pointed the weapon at him, which of course put him in fear of his life or great bodily harm, which would constitute assault. Like, I think people confuse assault and battery. Battery is where you rear back and slug somebody. You make contact, you cause them a harm by physically touching them, which can include grabbing somebody, snatching somebody's phone out of their hand. It can include you throwing something at somebody. Those all constitute battery, at least here in the state of Illinois. But assault is different. But as to that question, whether or not they should go bench or jury, I would think I would be thinking long and hard about going bench here. I think this judge is fair. I mean, we're talking about whether or not he's stateside. I don't know. Most judges are, meaning that they tend to rule lean state, and they'll rule in favor on, on objections and things of that nature more frequently for the state than they will for the defense. But that's not uncommon. What he does seem to have a grasp on is the law, and he doesn't seem to have a horse in the race. Whereas the preceding judge, her behavior was so bizarre on the bench that you couldn't walk away from watching her presiding over this particular case without thinking, like, what is going on with this woman? Like, why does she seem to give a shit so much? Like, that's not the role of a judge. So I'll know more. I'll give a more informed opinion on whether or not I think they should go bench, because there's an inherent risk in that. You're leaving it to one person as opposed to 8 or 12, whatever they're going to have. I don't know if this would be a petit jury, if it'll be a full 12 people in the box. It's always a risky endeavor. And you can argue it both ways. Yeah, it's harder to convince 12 people to acquit. I mean, we saw to what lengths Karen Reed had to go to get acquitted. 2 trials, defense team for the ages, fought everything to the death, every single fact that the Commonwealth was bringing in that case. I mean, that's hard to do. Both things, getting a defense team together like that and then convincing 12 people to acquit is hard. Most people in this country, you're sitting in that defendant's chair, you're getting convicted. It's facts. Just Google it. Conviction rates are always in the 90s. If you're sitting in that chair, the likelihood is you're getting convicted. So when Allie gets back, we'll discuss that concept.
Put as much of the questions you folks think are relevant in the questionnaire, so that it just will speed up the process. Obviously, you'll have your own things that you'll want to maybe ask personally, which means that the questions have have to be formulated in a yes or no, in a manner that calls for a yes or no answer. So when I look at the defendant's request, I mean, I definitely can include something like A, B, C, mental health issues in general, and
Accurate.
yeah, D will be in there, E will be in there. Yeah, F I don't ask, I'm not saying that you can't, but same thing with G. I mean, there's obviously versions of F and G when they're asked whether they can obey the idea of the presumption of innocence and reasonable doubt, et cetera. But same thing with H and I and J. So all of those things are kind of covered, but you'll be free to ask follow-up questions or questions that are that pertain to that. Now, so on the K, I'll formulate something. Does it make sense to have some?
All right, we're getting half the story here. I'm going to give you all context. Allie might yell at me when she comes back, but I'm going to go through the questions that they want to ask because he's just going through it alphabetically. I think for us, for all of us, including me, I like to have the context of what he is asking the judge if they will be able to ask jurors, prospective jurors during voir dire. So A was, have you had any involvement with domestic or other restraining orders? Fair question. That should definitely be allowed to be asked. What? Huh? Allie agrees. B, have you had any involvement with contested child custody matters? I think it's fair. I think it's fair. If they're going to let them get into the 209A stuff, I think that's absolutely a fair question. And it sounds like they're going to allow them to get into the 209A stuff, which again is when Justin went in ex parte without Kelsey or anybody representing her being present, made representations to a judge, and he walked out of there with full custody of his kid based merely on what he said to a judge. Uncontested. All right, so C is there may be references to a suicide attempt. Is there anything about that topic that would make it difficult for you to sit as a juror on the case? It's definitely fair game. That is 100% a question that needs to be asked. You need to know. I mean, voir dire is incredibly important. It's the only time that we as attorneys have the opportunity to try to glean something about these people that we're about to put in a box who are going to sit as fact finders and ultimately the judges of whether or not this person's going to be found guilty or acquitted. You know, which is a very, very hard thing to do. You know, typically Allie and I, especially as social media progressed, you know, we wouldn't get our jury questionnaires until the morning of. So we'd walk into court, the court clerk would say, here's the pile of prospective jurors. And it's a pretty basic questionnaire, you know, marital status, occupation, education level, you know, address, age, you know, and then it'll ask other various questions. You know, do you have anybody that works as an attorney, a friend or family that works as an attorney, law enforcement on the bench, you know, all those types of things. So it's pretty limited, but like I would get them and I'd go right onto Facebook because I'd be trying to figure out some shit about this person because I want to know who they are. I want to know if I can, how they think about things. I want to know if they have personal experience with things that will cause them to be biased about certain things. I mean, if you've got somebody who has themselves attempted suicide, but was not successful, or a loved one that has done it, they're going to have feelings about it, which may or may not be helpful to Kelsey if that person's sitting on the jury. So I think that's a fair question. D, is any member of your family or a close personal friend employed or retired from serving as a cop or other law enforcement. So that's fair game. That's usually those types of questions are typically asked by the judge. So are you now or were you ever a member of law enforcement agency, public or private, in civilian or military life, whether paid or voluntary? Fair. Because again, you know, we got cops involved here, and you want to know how people feel about cops. You know, and there's always questions about, depending on what type of case it is, if it's a battery case, if it's harm against children, you know, you want to know from those jurors if they have any personal experience with that in their lives. And more often than not, people do. And more often than not, if the jurors are being honest, which is all we ever ask. This isn't about judging whether or not you're a good person or not. It's judging whether or not somebody is going to be biased or have just this bias coming in that they're not going to be able to overcome and put aside in terms of what their job is, what their civic duty is sitting as a juror. Because we're human. We're allowed to feel certain ways. Our life experiences are what our lens is made from, in which we view everything through our own personal lens, which is based on our own personal experiences. So, you know, and honest jurors will be like, yeah, you know, so-and-so in my family was a victim of this type of crime. And it was devastating for us. And I'm just here to tell you, you know, just knowing it's that same type of case, I'm telling you, I have a bias. I don't know if I'll be able to put it aside. That is a gift to every attorney in that room, because everybody wants to know that. That is not a good candidate for a juror on that particular case. All right. So F is, when you learn that the police have arrested or charged a person for a crime, what do you say to yourself concerning the likelihood that that person is in fact guilty of the crime? This is Allison's favorite question. It's typically her first question. And I'll read it again. From what you learn that the police have arrested or charged a person for a crime, that alone, what do you say to yourself concerning the likelihood that that person is in fact guilty of the crime? Meaning, just by way of the fact that this person was arrested, do you think, well, they probably did something? It's an absolutely fair question, and it's a question that needs to be answered, because a lot of people feel that way. It's a fact. A lot of people feel that way. Well, you know, they're sitting here, they're in court, they must have done some shit wrong. Can't have that. That presumption of innocence thing, you know, people like to say, oh, that only matters when you're, you know, on a jury. Well, no, it's a mindset. Because you never know where you're going to get called as a juror. And you shouldn't just have to turn that on like a light switch. It's the way you should think about it, because that's how this thing works in our country. We have a presumption of innocence as citizens, and the state has to prove whatever they're alleging we did beyond a reasonable doubt. I feel very uncomfortable with somebody who doesn't give a shit about the presumption of innocence for 30, 40 years in their life. They just assume everybody's guilty, and then have some kind of bizarre, unreasonable expectation that that person's going to be able to turn on a light switch and abide by the presumption of innocence when they're sitting in that jury box. No, sorry. It's not how that shit works. So it's a state of mind. Say it all the time. See that little thing? I love due process. No one talks about due process more than Allison and I. No one. No other law tuber. They just don't. Because it matters. It's everything in terms of the criminal justice system. Without due process, we have nothing. Understand that. G, do you believe a person would not be arrested or charged unless he had done something wrong? Great follow-up to question F.
Yep.
It goes back to that thing. Well, they're here for a reason. Must have done something wrong. Okay, H is, do you believe that if someone is arrested, indicted, or charged with a crime, then he or she must therefore be guilty of some crime? Again, another follow-up, same vein. Do you believe that a criminal defendant should testify at his trial in order to help establish his innocence? I love every one of these questions, and every one of them is absolutely fair game. Every one of them. There's something I want you to think about. I know you were listening while you were preparing lunch. There she goes. Oh, there she is. What are you doing?
I had to have the camera off temporarily.
Oh my God. I want you to think about bench or jury on this case.
So I think that
No, I just want you to think about it
Okay.
while I'm going through this. I don't mean to interrupt you, but let's watch this judge. Let's check out his demeanor and mute it. I can hear my dad like
I'm trying.
walking in the background. Allison, I gotta go to the bathroom. I'm walking by. All right, so I is a very important question. I mean, there is a jury, there's a jury instruction that always tells the jurors that, look, you cannot have any kind of feeling at all about whether or not the defendant testifies in this case. You cannot consider that. It cannot be a thing where you're like, well, hey man, if they accuse me of some shit and I'm innocent, there's no way I wouldn't get on the stand and tell my truth, man. It's not how this shit works. You don't get to do that. You cannot consider that.
You
And
sound
but-
just like Justin there.
Yeah, but
Doped up.
after he's blasted a huge blunt.
Yeah.
But I want to know that on the front end. Meaning, like, I want to know that before they get on that jury. Because, it's debatable how much jury instructions really impact people. You like to think that they follow them like it's been handed down from God and that they'll go to hell if they don't follow the rules. I don't know that that's the case. I don't know that
Birdman's wife's still out of town. He's still going.
Woo! Hey, that pocket full of dimes. Is that a tip of the cap to Buried? It sure seems like it, because that was the name of episode 3 of Buried inside the John Wayne Gacy investigation, which you
If
should
you
all
haven't
listen
heard
to.
it, go listen.
It's the best podcast on the planet. I'll die on
Wherever
that
you
hill.
get your podcast, not YouTube, real podcasts.
Yeah, actual potties. All right, so Jay, does the fact that Miss Fitzsimmons is sitting here today facing charges make you think that she must have done something wrong?
So did we see this in Karen Reed? They have to do this in every case, or is the judge taking special precautions here? Because we never have to tell the judge what we're going to ask ahead of time. I had it happen in.
I mean, there's
a
been a couple
federal
of
court.
judges. No, there have been a couple of state judges where, like, our favorite judge did that. Whatever that trial was that we did down in the basement, I can't remember which one that was. Remember that trial? I can't remember which case that was. Of the down in the basement
I
of
know
King
where
County.
you mean. I just can't even.
I
think of
can't
ever
even
having a
with that
trial there.
case. Yeah. But I remember the judge in that, and I feel like Barsanti was one who wanted
All
to
right,
know
so
what we were gonna.
sometimes they do, but
Yeah.
did they? And people are saying yes, they did in Karen Reed. Maybe they have to do it for.
I mean, that really is a judge by judge thing, whether or not how they're going to
It might
handle
be
it
their
for you.
rules too. Might require it.
Yeah. All right. So, Kay, do you belong or support any organization or group, religious or otherwise, whose philosophy or beliefs would make it difficult for you to decide the issues in a criminal case? Again, fair. And then, do you understand the proposition that if you view two competing versions of the facts of the case to be equally likely, that is not proof beyond a reasonable doubt? So that's what we're dealing with. Those are the questions, babe.
That's it.
Well, those are it was it was A through L.
Well, it's missing my other second favorite questions about if you believe that the state, and I do it both ways, has not met its burden, but every other one of your fellow jurors thinks that he is. After you listen to everything, if you still are not convinced, will you not care what everyone else says and stand firm in your own convictions.
And I honestly don't know if people can honestly answer that. You know what I mean?
Just
Because
to keep putting it in their head. Then I ask
I-
them if it's a long weekend, you know, you
No,
want to go
is-
home, but you're not
I am in
convinced.
no way suggesting that you shouldn't ask that question because it's an incredibly important question. What I'm saying is, I don't know if prospective jurors, if they've never done it before, can answer it. Because like, in what experience in life, like serving as a juror in a
Babe,
jury,
Here's the thing with those questions. I don't care what their answer is or if they answer it. I just want them to hear me saying it
I
over and over and over again
I
so
heard
that
you say that.
when the situation arises,
I heard you say that. What
they'll be
I'm
like,
saying, I don't think it's going to impact them that way. Like, oh, that
well,
attorney kept asking me if I'm going to be able to do that. If they're a meek person, if they're a person that has a hard time standing up to bullies, or and if you got a bully on the jury, and that person, like, they're not going to be able to change their personality because they're sitting
well,
back
some
in that
people do
deliberation.
answer and say, I think I would have a hard time
Yeah,
standing firm.
that's why I'm saying, like, that person's a little more in tune with how they might react in an 11 against 1 situation.
Right.
Like, you'll meet people that are like, I don't give a fuck what anybody says. Nobody's changing my mind on jack shit unless I believe it. You know what I mean? Like, that's who you want. But my point being, you don't really know until you're in the situation. Does that make sense? All right, let's get back to it.
Kind of question related to groups such as, I don't know if this is still pertinent, this is from years ago, fathers' rights groups, correct? Groups that may advocate for Second Amendment issues. I don't know, things of that nature, they can be grouped together, but I think K is too broad. So I'd be amenable to, again, asking for, if they've ever, if a potential juror has ever donated to or volunteered for a domestic violence related organization, or if that's what folks think, or some kind of a shared parenting organization related to that.
Yes, I think we should do something like that. That's your like that.
Okay, so on the Commonwealth and page 63, I think I cover almost all of this, at least on the first page, second page. So it does make sense to ask about, as the defense requested suicide, mental health in general, postpartum, even. I can formulate some questions related to that. Training experience with mental health issues. I don't know, is mental health going to be a issue? Well, it's going to come up at some point, right? Even on a limited basis.
I think it's going to be very tangential. I think it's really more about, and actually, my brother and I just hatched out an agreement that
I always get
the way that this
confused
was
when they
served,
say
as
my
they all
brother.
are, is without an affidavit. It was just served. The order was served, and I think we have a stipulation that we can just admit what was served, the restraining order, and the terms of the restraining order are what we both literally just discussed this, what we both are interested in utilizing. So I think that will probably cover the issues that we both are concerned about without opening too many doors on either side.
So I guess the question is, do you think I should stay away from 8, 9, and 10 and 11? Or do you, that being on a Commonwealth request, or do you think that those things are worth asking about?
So I have an objection to 8, 9, and 10 because I think it's kind of suggesting things that aren't going to come up. Mental health disorders, I don't think that's really going to be something that's going to be discussed at this trial.
But you folks are asking about suicide, so wouldn't that beg the question? I mean, obviously, there's many reasons that people commit suicide.
Not necessarily, I don't want to invite some sort of wide-ranging exploration of, Ms. Fitzsimmons' medical history. Not to suggest there really is anything that's, awful. I mean, we have postpartum depression. Whether that becomes an issue in this case, I don't expect so. I think she was served with an order that did 4 incredible things to her life and would do 4 incredible things to anybody's psyche. She lost her 4-month-old child in the completely out of the blue. She's home with a baby in sweatpants having fun. She loses her 4-month-old child. She's betrayed by her fiance. Her marriage is over, ain't gonna happen necessarily. And you can picture her sort of almost having this realization. Her job's over, her guns are gone. Again, she just got them back there was a 100-page report clearing her of anything and putting her back at work. She was going on schedule in 3 or 4 days.
Los Pollos says, one person says this, the other person says that. We have to wait for both sides. True. However, so far in this stream, we're only getting one side. Here's the deal, Los Pollos. We already got the other side by way of Justin going in and filing an affidavit in terms of getting that 209. We know
But
what his story is.
He or she is right. I guess he is right that in this stream, we did not go over Justin's allegations against Kelsey. We did not.
Right. We've done that in the other stream.
We have. We've done that. We have done that. And
We've
I guess
gone through it before. This is the first we've heard from the defense's side in terms of what their story is. Does that make sense?
And the other thing is that she was completely humiliated in front of her own work friends and colleagues. So I don't think we need to really go to dig up any sort of diagnoses, especially something as common and expected in a woman as postpartum depression as a reason for wanting to just end it all in a brief, half-hearted manner.
Okay. So the bottom line is you object, the defendant objects to 8, 9, 10. How about 11? Just the training related to mental health.
That one,
Look at the Commonwealth
So 8 to 10.
request.
So let's just take them a bit at a time. Commonwealth, from your perspective, as to 8, 9, and 10.
Obviously, we can't predict how the trial is going to proceed. However, based on counsel's representations here and prior public representations, it seems like the defense is going to be that, based on the confluence of those 4 factors, the defendant claims that she was attempting a suicide attempt. I don't know how you divorce suicide from mental health issues. I think that the two are one and the
kind
same.
of
When someone
agree.
hears suicide, particularly in a jury pool, they're going to think mental health. I think it's going to come up that why did Justin have it? It's not guaranteed to come up, but the fact of the 209A order suggests that there was a reason why a neutral magistrate determined that Mr. Alien should have custody of the child. So I think mental health is an integral part of the case. The Commonwealth is not shying away from that. I think that we need to ask the jury about it because depending on how this trial goes, it could be very narrow. It could be a 1-day-long trial. It could be much longer depending on how things go. So I think we need to really probe the jury and find out any biases that they may or may not have with respect to mental health in general.
Okay, mental health is an easier concept broadly because it's been raised somewhat by the suicide request by the defendant. But as for specifics related to postpartum, so does the Commonwealth believe, just in your case in chief, that would somehow come out?
No, but I mean, there are signs outside.
I'll take you up on that.
Postpartum depression is not a crime. So it would be.
And yeah, how can I remember? I'm surprised that this, Mr. Bradl, the postpartum depression is controversial for the defendant's end because I thought I read in some submission somewhere.
And we're glad you're feeling better, Spitfire.
From your perspective, right?
So as we're evolving kind of towards trial, Your Honor, it occurs to me that the case is really, it doesn't matter much about why the person got an order, what was going on with these people. The police are serving an order. That's their legal duty. It doesn't matter what the order says or how it was gotten, or whether it's based on truthful information or fraudulent information. They have a duty to serve an order.
Okay, but let me ask you, tell me the facts about the service, the actual service of the order. And that is that, does the Commonwealth believe that the evidence will be that the defendant read the order and understood it before, in other words, processed it somehow and before the shoot?
Yes, you process the order, not the affidavit.
Not because the affidavit wasn't there. All right, so Mr. Bradl, presumably.
Ugh.
She processed it.
What the fuck? Yeah, I processed the fact that you're coming to steal my kid in the minute and a half that it took me to walk upstairs.
I mean, they're saying
See,
she seems
dude,
to be saying she read the order.
she said she processed it.
The judge asked, did she read and process?
And she said she processed it. She hadn't read the affidavit. Would had all. Do you care about whatever factual bullshit
No.
has been put forth to the judge in order to get the order, or do you care that they're coming to take your baby? I'm giving 0 fucks about why, other than you're coming to do it. Like initially, I'm like, what? I just try to put yourself in that position if you can for one moment. Anybody. Your 4-month-old baby, you get a knock on the door, completely unexpected, and you got a bunch of cops coming to say, we're coming to take your baby away.
I was starting to say, I wonder if I assume that she's going to testify in this case, but I could be wrong.
I think she
Um,
has to.
But I wonder, in my mind, she is telling him when he's acting like a drunken, drugged out fool at the party, like, oh yeah, then I'm gonna take our big, like if somehow breakup was being thrown around, that there was like a threat, like, you're not gonna see the baby. You're an alcoholic. You can't be trusted with our kid. And this was, like we've all been saying, complete. I'm gonna get my foot in the door first before she tries to deny me access to my baby, all in response to a fucking stupid fight about him overdoing it on drugs and alcohol.
Yeah. Lady Di asked an interesting question. Bob, to be frank, if you think that way, then why ask any question at all? Relating back to your question about whether or not will they be able to hold up against the fury of 11 other jurors, it's a different situation, Lady Di. It's a completely different situation. What I'm suggesting there is like if you're asking questions about people's potential bias, and again,
Wait.
all we can ever ask is to be honest. So that question,
I know
think-
Bob's making a point, but I'm certain he feels even though they couldn't answer that question, that
Oh, yeah.
just the mere fact of asking it is important.
100%.
My question.
Absolutely. My point is that like the reality of that situation in terms of whether or not somebody can withstand the heat of an 11-1 where they're trying to be like, dude, we've been on trial for 3 weeks. We're fucking over this case. You need to come along with us on this shit. You're the only one. Like if they can withstand that kind of thing, what I'm saying is I don't know unless you've experienced it. Just like I say, for any kind of situation that you've never experienced, like an emergency type situation that's completely foreign to you, you just don't know how you're going to respond until you're in that moment. You know what I'm saying? So like, that's my whole thing. I guess it really goes to more to weight, how much weight I give the answer than whether or not to ask the question. Cause I 100% think the question has to be asked.
Yeah, and it's
We
time to
wanna
hunt
know.
down it's time to hunt down Justin's ex-girlfriends to get the vengeful uh what's the word I'm looking for? Tit for tat.
Wait, what?
Spiteful. His general spiteful manner when he breaks up with a girl.
Oh yeah. The man scorn shit.
Yeah.
Yeah. Well, this is different because it involves the custody of a child.
Guy's an animal.
I mean, it's like that trumps everything. It's like I saw somebody say that Justin or Melanie calls Justin in it for the money. He's just in it for like I think that he's probably being prodded by his mother, and he's trying to get custody of that kid. Just in it for the baby.
Yep, Jody said the same thing. All right, let's
You
go.
said this, is that your client's state of mind is significant, right?
Right.
Because she has to have intent, right? And there was some mention in some filings about perhaps she's pointing the gun at herself. You asked about the suicide attempt. So I'm
So my-
trying to see how just asking a question about postpartum depression somehow prejudices the defendant.
My
I'm
thought
not
is,
suggesting that it would be admissible or not.
Right.
It's just a question.
right, I mean, I'm concerned about the degree of disclosure, and I feel like, the second it gets mentioned, that the government's gonna allege that we've opened the door or something, and that all of her prior incidents are relevant, and now they have to come in about postpartum depression. So, where I have an order that did those things that I just recited a few minutes ago, I don't really think that, we don't even feel the lily here on, and on top of that, she had a bit of postpartum depression. Like, I mean, how far do I have to go? I mean, those things that I said are eye-popping, to have that happen to anybody out of the blue on a nice summer day when you're home with your baby.
Especially if there's something to mental health this time.
I agree.
I am 100% with the judge on this. I think and I want to hear your opinion as a mother and as a woman. I think you lean into the postpartum. It's a fact.
I know, but I think they're worried that people can say, take mental illness and take postpartum and take it to the extreme of she might have been so out of her mind she tried to shoot this cop.
Maybe.
If she was willing to kill herself with her baby in the other room while they're taking her baby away, maybe she really was willing to kill this cop.
Guilty Lily here on, and on top of that, she has a bit of postpartum depression. Like, I mean, how far do I have to go? I mean, those things that I said are eye-popping. To have that happen to anybody out of the blue on a nice summer day when you're home with your baby.
Especially if they're suffering from mental health
I agree.
conditions.
I agree, but I don't want to open the door. And if
You're not, so let's be clear. We still need to go down on, at least I think we do, on what is admissible broadly in this area. All I'm addressing right now is the simple yes or no question related to postpartum depression. And that is whether they have any experience. I could use something similar to Ms. Moriarty, in the Brito case, where there was a significant mental health issue or issues. And it would just be yes or no. It's not, I would never say there'll be evidence that the defendant, it's just.
Oh, he's going to answer the
you're
questions.
giving me a comfort level, Judge, and I'm okay.
Okay, but the other thing too is just understand this, is that I'm going to take the information that we gleaned.
Did you want me to pause it?
No, it's just the judge is going to be the one asking these questions, not the lawyers.
Right.
That's a big hit. Lawyers not getting to talk to the
Well,
jurors.
I don't know if these questions are. Do you think it's to the exclusion of lawyers asking anything? You think
Oh
he
no,
just
maybe
has
that's
all
what
of
he's
it?
asking is what they want him to ask. Maybe that's where we stand.
Yeah, because I think that there's a certain weight
Yeah, when it comes from the judge,
juror,
for sure.
for sure.
I don't know why. Just that makes more sense. Maybe why he's asking them to provide the written as well, so that they'll still get to question the jurors. Okay.
Yeah, I mean, maybe not though. I mean, maybe he does ask all of them.
We discuss now, put it in a draft of a questionnaire that we'll go over before it's disseminated, and you'll have an opportunity to see exactly what it is I'm asking. I was hoping that would be today, before they're disseminated. Before I forget, while we're talking about, so give me an opportunity to put that in there.
I'm okay with it.
And
Just give me a comfort level, Judge. I'm okay.
You don't need to be comfortable. All you have to be comfortable is that it's going to be in the draft, and you'll have an opportunity to see exactly what I'll want to ask. And that's for all of these questions. But I hate to float around, but one of the issues I have is related to the draft of the juror questionnaire. Is I think that there's obviously media attention to this case, there's public attention. The public and the media have a right to end the defendant to a public and fair trial. I'm concerned about having a draft of the juror questionnaire getting out there by mistake or et cetera. So I'd be inclined to simply impound it, disseminate it for your eyes only, for obviously.
It's out there now, Your Honor.
Your time, and just impound it until we get to, and then we can talk about what we do with the final one as well. Any objections to that from either side?
No, I think.
Bobby just read them to the world.
Okay, all right, so
I couldn't hear you, baby.
I said they're out there now, Your Honor. Bobby just read them to the world.
Oh yeah.
It's all 1,262 people right now.
Oh yeah.
all right, so I think that, does that cover everything? I think firearms related questions in Second Amendment is type of stuff that I typically ask in a firearm possession case would be pertinent. Again, why don't you folks just with an open mind, take a look at what I write, what I draft, and you can object or take it out. Just look at the rest of this. Yeah, all of the rest of the questions would be included.
Your Honor, if I may add one that was not written.
Sure.
If you are going to reference, at least how defense counsel has it phrased, there may be references to suicide attempt. I think that is a way that gets the jury comfortable with the defendant's theory of the case. The Commonwealth would ask if that's the way it's phrased.
No, check my, because it's not going, it won't be phrased like that. At least initially when I drafted, I think that all of these questions have to be neutral. they have to be used from both sides, in fairness, but more importantly, again, it's not, I don't like asking questions that are case specific. The evidence may show, because it may not. So the issue is whether they have a personal experience with suicide, all right? Again, from the defense perspective, and that's what they'll be asked, something like that.
I would just like to raise the point of suicide suggests that the person committed a violent act themselves. The Commonwealth, one of the Commonwealth theories may be that it was an intended suicide by cop. So that,
Oh,
so I just think that if you're going to consider that in drafting your questions.
oh, so in other words, you'd like to, perhaps a question that would cover so-called suicide by cop?
Yes.
All right, so let me just,
Wow. She's a fucking cop. You're going to tell the jury that her way of committing suicide was to kill a fellow cop so that he would kill her.
Well, you don't kill the cop, you just point your gun at the cop for them to kill you. I mean, that's the concept of suicide by cop.
All right. Well, if that's the,
I mean, Kelsey's look right there says it all.
I know, but it's that's a real fear.
It is a
That,
huge fear.
that's why the question of, are they going to lean into suicide at all? Because
Well, I mean, from what I understand, Kelsey's story is that she was, you know, like put the gun up to her head. From what I understand the story.
right. I mean, I think that the way that you'd have to go about this is that as she was putting the gun up to her head, all the other cop was thinking is, oh my God, she is grabbing that gun. She's about to shoot me, before he could even process and realize where she was going with it. That's the way you'd have to present it. I'm not saying that that's necessarily what happened, right? Is that so that people can think both of the cops in this situation are good. You know, she was not pointing it at him. He did not just shoot her just because, you know what I mean? Because
Yeah.
that might be a hard pill for them to swallow too. Why would her very partner, was it her partner?
Former
Or
partner,
just right, just
Yeah.
shoot her in cold blood, you know?
chest shot. No
Right.
less.
So that's how I think I would be. The only way to present it is that this was a cop who just, you know,
Reacted in a
reacted,
moment.
thinking before he had even time to process, because that's what cops have to do. They have to think, they have to like that, because if she wasn't headed up to her head, he could have been dead, but
Yeah,
she
we're
was.
talking probably like a 15-second period of time.
So it's literally a he said, she said. I don't think you want to make it seem like you're calling that cop a liar, even if we all are. Even if in our own minds we think that fucking cop is a lying son of a bitch. That's not the way I think you present it in the court of law. And going to your jury versus bench trial, if you presented it that way, I think you might have a damn good chance with a bench.
So do
Because
I.
because
I
the
think
judge
you
can
argue
decide.
it exactly how you do. It's like the gun doesn't even get to where it's going. Like, you know what I mean? Like, you don't even get it up to, she put it up to her head or she aimed it at me. It's like in that split second when she's got a weapon that, you know, whatever he's thinking, mistaken or not, he reacted.
Right. And
You
in
know,
his
but
mind,
that
she was,
ultimately ends up in her being not guilty.
and in his mind, she was pointing it at him. Like that's the
Right.
way he processed it, because it was that quick when it was just on its way up.
Right, because the mens rea has to be established.
And then there is no ability for the defense, for the prosecution to disprove that. That is literally he said, she said, with where perception is subjective. And you can't disprove that she was headed to her head, and can't disprove that he, on its way to his head, thought it was pointed at him to a certain extent.
I'm
Now, depending,
going bench on this thing. Like I'm going bench on it.
it depends, because if this cop's going to say, Your Honor, I was staring down the barrel. I was staring down the barrel. Isn't it going to be easier to convince a jury of 12 that that's what that cop has to tell himself, either to, like,
But I think that
for his
there's
own
some
conscience?
facts, babe. I'm sorry to interrupt you. I think that there's facts that the cop had said that she had closed the door. But then I think there's evidence out there that the
There's no
bedroom
door.
didn't even have a door.
Yeah,
Which
actually,
goes to his perception in time, in that moment in time, was not good.
Julie
You
Jensen
trust
says,
it.
I watched one of Mel's streams. And again, that's attorney Melanie Little. If you aren't already following her, go ahead and follow her. She has covered this case from minute to minute since it happened. I watched one of Mel's streams and she showed Kelsey's home on the Realty website. Cops said she grabbed the gun behind the bedroom door, but there was no door in the Realty photo.
Mm.
So, and that's where I think you can get away with the argument that your mind recreates what your mind wants to be sometimes. And for him, he made a split decision. He thought that was the situation when it happened. And that's the only thing he can see when he looks back on it now.
Right. I mean, you can't really trust your memory in
Right.
that type of situation, like in terms of every detail. And like you said, your mind is going to remember whatever it thinks it remembers, whether it's accurate or not, and that becomes your truth.
Right.
You know what I'm saying? So, because in that kind of a split moment type of situation, it's just,
I'm not sure that I'm that creative. I'll have the ability to artfully draft something like that, but we'll put a placeholder in there. I'll do the best I can, and then you folks will.
Just to chime in on that, I'm not crazy about that because it's too specific, too suggestive, and it just adopts the Commonwealth theories. So I think the topical reference should be where it begins and ends. Just put my position.
Okay, so it seems to me that they're going to be asked, like in any serious case, whether they or a person close to them have been a victim of a violent crime. So typically I ask that, maybe, or been accused of perpetrating a violent crime. Maybe it needs to be shooting related, that question, or firearm related or something. But again, I'll draft a few questions that I think are appropriate. Folks will weigh in and we'll hammer them out. Anything else, just generally on voir dire, on the juror questionnaire? Nothing. And then, what else did I want to say about I have to tell you, from my perspective, you folks tell me you know your case better than I do. I think that the impanelment will take 2 to 3 times as long as the trial.
The what? The jury.
he said the impanelment will take 2 to 3 times longer than the trial.
Yeah.
I mean, that's the other part of this. I mean, there's without question, bench trials are way, way faster than jury trials. To me, I mean, we'd obviously be discussing it quite a bit, and ultimately, it's the client's choice, and that's not the lawyer's
Right, but
choice.
we need to decide what we would suggest to her.
Right.
And it's just.
I mean,
a lot of times
mean,
we just have to give them both sides and say it's a gut call.
I'm
Most
leaning
of the
heavily
time-
on bench on this one.
Really.
I just think that there's a distinction there with assault.
And I just
Like
think
the judge, I don't think the judge will be nearly as swayed by anything that's not factual. Like you're not gonna have to worry about the emotion side of it at all
Right.
with the judge. He's gonna look at it in terms of beyond a reasonable doubt. We know that he understands what that is. And in this case where there's just no evidence other than testimonial from 2 people who, like we said, are going to have whatever their memories of that moment in time are, and you have to give them the appropriate weight.
I wonder if the defense could have called a memory expert to say how people create memories from traumatic events like that, and studies that show that people hold very true the misconceptions they formed while the event was happening, like you kind of just said, because that might be the difference between the inability to even find guilt. I mean, I think in this case, there is no way for them to prove it beyond a reasonable doubt because you've got 2 different people's stories and no reason
Exactly.
to trust one over the other, unless there's someone else in that room that says they saw the same thing. I don't know. Was there a second cop that says he saw the same thing?
I don't think so. I think
So-
they were the only 2 in the room.
They're saying it was suicide by cop. We're saying it was suicide. There is no way to prove one to prove suicide by cop over suicide.
I
Literally.
agree. That's why I'm saying bench on this thing. So Kim,
And
Carolina
that's
said,
why they're worried about the postpartum depression thing or the mental illness that, well, but she is the one that was mentally ill at the time.
well, so I think the pushback on that is she was cleared to go back to work. So
Yeah.
was postpartum still in, the full throes of postpartum depression? Sounds like it wasn't. I'm assuming they're not putting a cop back on the street with a gun strapped to her hip back on the street if
That's a
she's still
danger.
in the depths of postpartum.
Right.
You know what I'm saying?
Or that it rises to the level of posing any sort of danger.
Yeah, or
But
threat.
yes, read Kim Carolina's comment.
Oh, so Kim Carolina had said postpartum depression. It's no joke. Those who have it have expressed that it's much worse than any depression that you could imagine.
And that's the defense's fear that maybe some jurors could take that and give it as an excuse for maybe she did something that even she doesn't think she would have done.
Yeah,
But a maybe is not enough.
maybe it's not.
Maybe it's not
Maybe ain't it.
Nowhere near.
And I'd really urge you folks, from taking a look you probably have at the rules of professional conduct as it relates to trial publicity, and just do your best to make sure that we can get from the start a pool of potential jurors that are indifferent to the extent that we're able to. But I hope I'm wrong, but I really think that the panel will take to get 14. Anyone disagree?
I think that just depends on, what we potentially opens the door to.
Opens the door to what?
About how long the trial will be.
Who is this Larry Bird looking motherfucker here? This prosecutor.
Wishes he looked like
These
Larry Bird.
two prosecutors are kind of a little goofy looking. I mean, which means nothing other than they're a bit
He's
goofy.
got his
goofy looking.
monochromatic look, his nice gray. Or is that like a purplish tie or is that gray on gray?
He's got that face that, like, with that face right there. I don't know.
Okay, I'm not really understanding that, but I'm not sure that I need to. So let me talk a little bit about scheduling. So I'm going to assume that we start handling on the 23rd. We get jurors here in Lawrence on Monday, Tuesday, Wednesday, Thursday. We get the most jurors on Monday, and then the amount that we get are less than each day. I think that we should assume that it will take through Thursday, and that the trial, I should tell the
Start
jurors,
Monday.
Perhaps even in the questionnaire, that the trial would start on Friday or even the following Monday. I know you tell
We
me.
can think about that only because really it's just challenges. So, that sometimes makes a difference. I understand other challenges that we will be dealing with, obviously, as far as people knowing about the case and reading about the case and the like, but
Let me raise the number of challenges because I'm getting my water from you.
Write this down, babe.
Handful of trials I've been like telling me.
What?
He's given number of challenges and stuff. Write it down. Do you have a pen? I'll text it to you on my phone.
Wait, what's he doing?
He's saying how many challenges they're going to get and stuff.
Oh, yeah, I have a pen. I got
All right. Okay.
My little pad still has some paper left on it. Here's the other thing about a bench, though. Like all the things that we're concerned about a jury hearing or not hearing, which we're going through right now, the judge hears.
Knows. And he knows public sentiment. And I don't know, are they elected? Are they retained by election? Or they're on and then they're, I don't know.
I don't know either. If you're from Mass, how are your judges? Are they, I'm sure there's appointments, but once they're appointed, they then have to be reelected to stay on the bench. Like, how does that work out there?
Let me raise the number of challenges because I'm getting my water from you. The last handful of trials I've been like telling these, folks get more. But my memory is that on the criminal side, you get 4 and 1 extra if there's going to be any extra seated jurors. Frankly, whatever the rule says, I'm going to give you. I know. The council oftentimes tell me, well, in Essex County, judges typically do X amount. I don't care, whatever the rule is, and I don't have it in front of me, I think it's 5.
But we were just talking, I thought it was 4 and then a challenge for each extra juror.
So there'll
Each
be
alternate juror. So
6.
All right, I don't have my, but whatever the, we'll all research.
I agree with that, Judge. And then if there were 2 alternates, we get 2 more, so there's, typically 6.
No, Gwen, that's a great question. Bob and Allie, is a bench trial out if they're discussing jury questions? Absolutely not. You can
Morning of.
you can waive jury. Yeah, like you said.
I mean, it seems that they have decided, seemingly, that she's going to a jury trial because they haven't waived it yet. But
Well,
you could
I
change
mean,
your mind.
like you have to do this unless you've decided way ahead of time. I mean,
That's what
there's
I'm
been
saying.
plenty of cases where we've decided early on, but a lot of times, I mean, we were kind of last second on waiving.
No, for sure.
You know, I mean, and Bradl may feel some kind of way after this hearing.
I don't think that's the rule. I don't think the rule. I think the rule is for any that are over and above the 12, you get 1 more when it's not a light challenge. But again, it will be 5 or 6. We'll figure that out. But as for I need to tell the jurors the start date, and I also need to tell the jurors an expected end date for them to get that, when they'll get the case. So what I was going to propose is that they be told that the trial would start again on the actual trial, the evidence would start on that Friday or even following Monday, and that they would get the case by the following Friday, April 3rd, which is over estimating the length of the trial on purpose, so that we have open time.
Sure, I think we don't want someone going away. I totally agree with you. I don't know if it's going to take that many days, maybe I'm being naive, to find a jury.
Okay.
So, but we can maybe see where it goes. I mean, I think maybe we say we start on Thursday. Anything about the day?
Okay, yeah, we can even tell them that we'll start on Wednesday or something.
I mean, I think if this is a bench trial, it goes a day, maybe a day and a half. If it's a jury, it might go to the end of the week. But I mean, Bettero's arguing his motion. Bradl's not going to argue it. I mean, that's not to say that Tim wouldn't want to be there for it. And we're talking about Turtle Boy's motion dismissed. The mega motion is getting
When
heard.
is that?
I think it's on the 27th. The mega motion is up. So, but like Mark will be arguing that, like it's his motion. He'll argue it. And I mean, if Tim's in the middle of this thing, if it's still going, Tim's going to have to be here for this. So it's the way it works, but like, this isn't a surprise to the judge. I mean, the judge is well aware of what Bradl's schedule is, and that particular hearing is a conflict to a certain extent, but yeah.
As and see, I'm surprised, but don't be surprised when you get a draft of the juror questionnaire that it says that I estimate that the jury will get the case to begin their deliberations. I'm just going to probably just default that April 3rd, which is Friday, because then in the next sentence I'll say that thus therefore you should be available to serve the following week in case it lasts longer. All right. So let's talk about in this meeting we have more motions which we'll address, and this may be the subject of. But let's talk from the Commonwealth's perspective. I'm trying to get a handle on what exactly the evidence will be related to the purpose of the police being there, how much you expect to get in during your case in chief about this custody issue that was ordered, etc.
Well, the underlying facts that I expect to come out is that a restraining order was sought. Mr. Alien was at the PD. He gave the restraining order to the officers. 3 officers went over to the house. He stayed back until they called him to come get the child.
He stayed back.
They called him. He went. Was in the process of gathering things. The officers went upstairs after serving the restraining order, explaining what was happening to the defendant. The shooting occurred. The end. So I don't anticipate getting into more than, the jury really hearing more than that in the Commonwealth's case in chief.
Okay.
Subject to any of the motions that we have filed.
So maybe it makes sense to, let's start with paper 61 because this kind of segues into that. And that is the Commonwealth's motion to eliminate to prohibit questions regarding custody status. And actually, when you say custody status, you mean both the child custody and the pretrial detention aspect.
I do actually.
Okay, all right. So let me first, before I hear from you, Ms. Morali, is there an objection to either one of these items?
We don't expect to be going anything down that road about custody.
About either custody, about the custody issue related to the child, and about their
Well, only to the extent of the contents of the order that's being put in front of her, and that to the extent that it's just an obvious part of the whole thing is that she's packing back her baby, she's giving the baby to the police, to give to the father. Just what's in the order. I think we're probably in good shape on that in the sense that we're both agreeing we're going to stipulate to the order. This as an exhibit, and the order says what it says, and we're going to both use what it says in the order.
Are you seeing all the chat? The
What are they
judges in mass are appointed for life.
Wow.
That is fucking scary.
I mean, it's like the
My
Supreme
God.
Court. It's like the Supreme Court. I mean,
Hey, but it's not the Supreme Court where you're theoretically getting the best and the brightest. You
right.
get any old turd up on the bench and they're there for life.
Yeah, that's true.
Yikes. That's a scary proposition.
Okay.
So I think that's the extent. That's the extent that I.
All right. So obviously, you can argue and question witnesses based on reasonable inferences from the order, but doesn't the order mention custody, temporary custody? Do you folks have is there a copy of that? Is there a copy of the order? And I thought I saw it in the file.
So I think just the custody post June 30th, 2025. So insofar as the child is still with Mr. Elaine, I don't see how that's relevant. That was really so the fact of the fact, we're not disputing the facts of the matter is the 209A order granted.
Oh,
Mr. Elaine
you don't want
custody
them
of
to
the child.
know that y'all have denied this mother her child for 9 months. Oh, no, I think that's not relevant. You know when it's relevant? When you're trying to find out if what Mr. Elaine says on the stand should be believed. I think it's fucking relevant. I think it goes to his bias that he will do just about anything to backstab, hurt, destroy this woman. Anything. So fuck you. I think it's relevant.
Agreed. I'll allow it.
We just didn't want there to be additional on direct or cross of any witness, the current custody status of.
Say something.
Okay. I can't imagine you want that.
We don't.
Okay. All right.
Ugh,
So and then
they're
you
stupid.
anticipate, Mr. Bradl, that you would raise
Defense is
your
stupid.
client's pretrial detention status? All right. So then it seems to me that I can
I mean,
allow
I can see they don't want it to seem like.
without objection, as it is narrowly tailored.
Pause it real quick. I mean, I guess the fear is if the jurors think they did.
Wait, did you rethink it?
No, because the defense said, "Oh no, we don't want to get into it either," and I'm like, "You're stupid, defense." But I'm just saying, potentially they're thinking that the jury would think if she doesn't have her kid yet, some court somewhere has decided she did something wrong. She must have done something really wrong if mom hasn't seen her baby in this long. Because
yeah,
that's what you would think.
Right. I mean, that is a fair inference to take from it. So,
Although,
which then begs the question: how much are they going to allow in? I mean, they have to allow in, at the bare minimum, that this was an ex parte thing and it was just based on words and nothing more. I mean, it's like your classic Ipsy Dixit. I just said some shit, and the judge granted my motion, giving me temporary full custody of my kid. You know what I mean? It's like,
and
I
I mean,
think that at
maybe
least has to come in.
maybe they can say, and during the period that you had temporary full custody, without saying when, you denied any access to her, not only her, but to every one of her family members. I mean, I just think it's fucking relevant. I think it's relevant to him being
As to
truthful.
his credibility, yeah.
Correct, as to his credibility, not to the fact that they didn't get to see him, but as to whether this man will say anything right now to fuck her over, just as he did to her and her family at the expense of his own child.
Right. Because, I mean, who knows what he's going to get up there and say? Like, this
Yeah.
guy can get up there and say all kinds of shit.
So
Oh,
I
yeah,
think
she kept talking about killing herself all the time, blah, 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 which would probably come in as a, statement of a party opponent. If if that's what if the state's going to argue that this was potentially, suicide by cop, that, if Justin's going to get up there and say some bullshit, yeah, you got to be able to attack his credibility. You can't trust a goddamn thing that this guy says.
Right. And you can walk that line where we were saying, okay, well, we don't want the jurors thinking, well, shit, took a baby from a mother of mine. Now someone must have decided she did something, to just say, and during the period that you had temporary custody, without saying how long it is, when it ended, when it didn't.
Yeah.
You did this, you did that, you did this, you did that. You fucker.
So Jen had asked, isn't Bettero pro hoc? Does that mean he needs a mass lawyer with him? I don't know. Like, I don't know what the rules are. I mean, you have
In
to.
most states, you don't have to have that lawyer standing next to you. He has to
That's the
sponsor your
question.
application,
Right.
and he's supposed to be in the background helping you with the local rules and like checking your shit, but he doesn't have to stand next to you like your babysitter.
Well, see, but that's the question. We don't know what the law is or
In
what the local
Massachusetts.
rules.
In every
yeah.
state that I have done pro hoc, and we've done them in a lot,
Yeah.
there was never a time where the other lawyer had to be standing next to me at all times.
Until there was in Omaha.
But that was, they made a special rule for us.
Yeah. Yeah. Like at first they didn't need to be there, but they made it sound like they wanted him in the room. But it was so cumbersome for that local attorney's practice. But in this situation, Tim's co-counsel.
Right. So
it's not like he's
just
because a lot of times when you go with pro hoc is you just have a attorney that's going to sponsor you and they have no intent on doing any substantive work on the case.
Right.
But
that's not the case here. Right.
Because it goes back to that question about the mega motion being argued. It's definitely going to be Mark arguing. It's his drafted motion. Question is, does Bradl need to be there for it? I think the jury would, or the judge would probably give a waiver if that was the rule, unless
they've got some discretion.
Right.
So, just
Gonna sneeze again.
So then that brings us to paper 62. Commonwealth's
How much
motion
longer is this?
to preclude questioning regarding current duty status. So let me be more specific. My understanding is that Commonwealth is seeking to preclude evidence regarding the Officer Newton's now current status with the North Andover Police Department?
Yes.
And what is the status?
The Commonwealth's understanding is that he is on leave.
Yeah, he shot another cop.
All right, so you would want to preclude any mention
Fuck no.
of that Officer Newton is on leave?
Yes.
Okay, what do you say, Mr. Bradl?
Judge, I think that we're just talking here about perhaps putting this in advance so we get the IED files, because we have a lot of information that I think we have more information than the Commonwealth, frankly, about his status, that it may direct this debate in a better way.
Yeah, maybe I just defer ruling.
I think that makes sense. We can address all the issues kind of simultaneously.
Okay. So
How much time's left, eh?
Paper 64, defendant, Commonwealth's motion in Limine to admit prior bad acts if they become relevant. There's also some good acts on another motion, but go ahead.
With respect to the prior bad acts evidence, Your Honor, as captioned, the Commonwealth recognizes that those are not relevant to the Commonwealth's case in chief. However, in abundance of caution, the Commonwealth wanted to alert the court to evidence it had in its possession about prior bad acts in case they do become relevant based on opening, cross, or the defendant's case. So we can really hold those aside for now, but the Commonwealth just wanted to alert the court. And obviously, if the Commonwealth believed that a door was open, we would come to the sidebar before any questioning related to any of these issues.
Okay, so and I appreciate that you're being careful. So the bottom line is the Commonwealth is not seeking at this moment to admit other acts, but you may argue, as either side would argue during the course of the trial, if it arises that the door has been opened, and we'll have to address it at that time.
Yes, sir.
All right, so I'm not going to take any action
That's
on it.
fine.
No, that's easy.
If they put in her reputation for law-abidedness, then the state apparently has some prior bad acts that they want to get in.
Wait,
That's how
babe, say it again. Your mic's low. At least it's low for me. I couldn't hear anything you were saying when the court was still running.
Oh yeah.
and I want to
put it-
hear it.
I put it down. Maybe I'd move it back. Oh, it's still at 50.
That's
So
good.
what they're talking about there is if, for example, the defense were to put on witnesses about her reputation for law-abidedness, then they have some prior bad act evidence that they're going to seek to put on. So that's how the door would get. That's one example of how the door could get open. There may be other stuff that I don't know of or I'm not thinking of right now that would open the door on cross or whatever, but it would be inquiring to how amazing and law-abided she is.
Yeah.
Brings us to paper 65.
Law-abiding.
This is, Commonwealth's motion in limine to preclude questioning regarding promises, rewards, or accusers. And I'll hear you Commonwealth on that.
And this is a subject that we touched on last time.
Correct.
Just concerning the request for a promise for reward or inducement. And so I think we're kind of in a slippery slope, because if the council is able to ask the witness concerning post-event accusations, because these accusations that the defendant has made in unsworn statements and the like, is going to muddy the waters. One thing that
But which accusations are you talking about? The accusations related to Mr. Elaine allegedly breaking into the house, or the accusations about purported favorable treatment of Officer Renania?
I'm sorry, this is the alleged breaking and entering.
Okay.
Okay. And because it is post what we're talking about here, the Commonwealth has stated on the record, we're not pursuing that, and we're not pursuing that,
To tamper with
based on
evidence.
prosecutorial discretion, but
What?
To tamper with evidence. They're trying to say that that's not preferential treatment of a prosecution witness. He is not being charged.
Yes, exactly.
And they're trying, so go fuck yourself. What do you mean? Post of how is it any different that you're not charging him for any post, like, oh, I mean, he had already agreed to testify for us before he got this charge. Well, he's still getting preferential treatment in that he's not getting charged.
Yeah,
But I don't know. Let's see what the judge has to say about that.
that's huge preferential treatment.
But typically,
our prosecutorial ethics here, the Commonwealth has stated on the record, we're not pursuing that, and we're not pursuing that, not it's based on our prosecutorial discretion, but honestly, our prosecutorial ethics. This is these are allegations that were made by the defendant in unsworn statements that the Commonwealth believes many of them are just false. Mr. Elaine.
Is this fucking guy serious? We've all seen the video, you fucking moron. Like, is this guy for real? I
let's hear
see
what he's
him
about to say.
shoulder
We
the door in.
We seen it. So let's hear what he's about to say before we go off half cocked. But
Oh my
buddy,
God.
we've seen it. We've all seen it.
And poor man's Larry Bird over here. Look at that guy.
Was a resident of that home.
All right, hold on.
Yep.
I'm hoping that we don't have to relitigate or even litigate for the first time the alleged conduct. The bottom line is, the Commonwealth is seeking to preclude mention, Mr. Bradl, of the events of this breaking and entering, okay? And you object to that?
So I don't expect this trial to go down this side road, but to the extent, I don't think Elaine really is a relevant witness in the case. Granted, he's
Me
on the
neither.
premises, but he has marginal relevance. And I think that
It's kind of, that's what Mr. Kubakosi said the last year, but you didn't seem to agree, but so it will do pre-thought.
he's a dangerous witness, I think, for both sides, let's put it that way. And so it's a complicated scenario, Your Honor, that, if he does testify, that opens cross-examination. That might open some other doors too. But, I mean, if it was me, I don't think I would call Mr. Elaine, because it opens up all kinds of cans of worms, and he has testimony that's only duplicative of other people. And, the fact that he's there on the premises, let's put that aside for a minute, that they let the guy who gets an order to have someone stay away from him, they bring him to that premises, let's put that aside for a second. But he's like a straw man. There's nothing that he adds to the trial, and I'm going to cross-examine him, but I don't want to open up certain doors. So he's a very complicated witness. He's one of those kind of mistrial witnesses. So I don't know why they're calling him.
Get him, Tim.
Well,
I mean, that's
I'd
what we
like
were
to know
saying.
what door he doesn't. He doesn't want to open certain doors, he's saying. He doesn't want to open certain doors by going at him too much on cross-examination. So
Yeah.
he's trying to like scare the prosecution. Like it's a
Well,
good
it's
question.
exactly what we were saying in the beginning. Like that guy's a fucking like a field of landmines putting him on. He's like
And
the
he's got
gift that we keep on
no
giving.
relevant evidence.
Right. He's bringing nothing to the table. And I like how Tim's like, let's just put aside the fact that he's got a stay away order, but he's on the fucking property.
Right,
Let's not
because
even, we won't
typically
even
they'd
worry about
say,
that.
send a family member, your mother, your sister, your brother, your papa to come
Right.
get the baby, not have the other party to the dispute showing up at the house while they're serving the protective order.
Yeah. And if
But
there's none of those people available, typically it's law enforcement escorts you over there.
only if the order says that they're able to go in the house and get certain things.
That's what I'm
before they-
talking about.
Right,
The situation where they're coming to get property.
right.
Because many, oftentimes somebody runs in, gets an OP, and you're out as soon as you get served. You can't go back to the house, so you got to, unless they put it in there, like, okay, we're gonna let you go get your fucking underwear and toothbrush, but you got to have
Cops
either
come.
somebody else go do it, or the cops are going to escort you there to do it.
But if they, this is, I guess, my position, if they call them, then all bets are off.
So, I can't imagine that you're asking me to preclude the Commonwealth from calling.
No, it's not.
The Commonwealth has the burden of proof, and they're gonna, within the rules of law and evidence, that they're entitled to try to prove their case, just as Ms. Fitzsimmons is. The issue is, do you intend to ask Mr. Layden, if he testifies, isn't it true, Mr. Layden, that on such and such, whatever,
I'm with the judge on that dude's last name. Sounds exactly like alien. It's a tough word. Doesn't roll right off the tongue.
Elaine.
date, you busted down Ms. Fitzsimmons' door, went in and, stole things and et cetera.
Yes.
Okay, you intend to ask.
Yeah.
And that's,
Long thought.
again, understanding that some of this depends on what he says during the direct, and I totally get that. But just from a 10,000-foot view, how is it relevant?
So he's getting special treatment from the government, Your Honor, and
And?
he's
Bias.
been coddled and protected by the government from before the service of this order. There's all sorts, and then talk about open
Bias.
doors.
But why, in using your theory where he's this background witness, why would the Commonwealth be motivated to do that? And when I say the Commonwealth, yes, it's the district attorney's office be motivated to give him special treatment.
He's in.
Why
in
is
with
he
the
getting
people,
it?
Your Honor. We would be able to prove that he's in with the right people. I don't want to give you too much, but I hope you're satisfied with the direction that would go at this point. And he's in with the right people. They knew this was coming. Ms. Fitzsimmons was at the police station the morning of this event, being treated fine, brought the baby to the police station, took a CPR class to refresh for her upcoming appearance on duty schedule. She was treated wonderfully. She saw her friends. She did the training. She passed the training. She had the baby there. People are taking pictures with her. At the time, police administrative officials knew what Justin was doing that day. They knew he was going to do this. We had information, Your Honor, that when one of the gentlemen in the department said, "Oh wait, we got to get Kelsey her radio for July 4th." One of the administrative people said, "Oh no, just hold off on that. You don't know everything that's going on right now." They knew they were conspiring, to use the appropriate word. They were conspiring with Elaine before this service for this whole thing. And there's an entirely
They
other
were conspiring, I thought
with
you said-
Elaine too.
I thought you said Elaine.
Yeah, I'm sorry, with Justin Elaine. They were conspiring with him that he was going to go get this order. He was going to communicate with them. They're going to serve this order. And, not to put too fine a point on it, but there were many people in that department that didn't want Ms. Fitzsimmons to go back to work. And this served the police department's ends as well. To
Wow.
blow her up by serving this order in a certain way. So you see where I'm going. There's a lot of doors here, Judge.
Wow. What? That's
Wow.
some stuff right there.
Why they didn't want her coming back to work, huh?
Wow.
They didn't want her back in there, huh? Wow.
Wow.
What the fuck do you all in the chat know what something Bob and I don't know about what the hell this is? Why they wouldn't want her coming back? Like,
Wow.
I mean, it's Massachusetts. My mind could go a million ways. I mean, like,
Give us the tea. We
yeah.
want the tea.
A lot of
The doors are easy from my perspective, because it's about the rules of admissibility of evidence. So, it seems to me that, again, the narrow issue here is whether you get to cross Mr. Elaine on the fact that these facts related to his alleged breaking and entering.
And bias.
And from my perspective, it would only be relevant when you say special treatment is if somehow he's changed his story, right? So maybe some of this we'll have to hear his direct, but there would have to be some basis to cross him on it that he's somehow trying to curry favor by changing his story.
I think it also tends to explain the unorthodox manner of service of the order, Your Honor, in the sense that they let it go.
Why
to the
isn't he
house.
saying bias?
Okay,
I want to rip my hair out.
He's an adversarial litigant against the owner of that.
I can't hear you, baby.
Why isn't he saying bias? I want to rip my hair out.
Don't do
Why
it,
isn't he
baby.
saying it goes to bias? It goes to bias of the investigation. It goes to his bias and his motivation to say to be dishonest in an attempt to get a conviction here. That he will say and do anything. I just don't understand why that is not among because what the judge is saying here is this. All right. If he's doing it to curry favor, you need to have he changed his story somehow. He made because he was already agreeing to testify. He already gave a statement. So typically the thing is, they gave him a deal so that he would cooperate. He's already cooperated. So did he threaten to pull that cooperation? Did he make his statement harsher? What did he do in exchange for this? So I think the stronger way to get this in is going to bias again, that he will do anything to keep this woman out, to keep that baby for himself, to hurt her, including wrongfully testify to get her convicted so that he doesn't have anyone interfering with his daddy time and he doesn't have to pay any child support. And she's punished for whatever he thinks she needed to be punished for.
And his mom's all up in his ass.
Right.
Give
And
me
his
that
mom is
baby.
the only grandmother the baby needs to love.
I am the grandmother of that baby. You bring him to me.
That would be like if you could have ran that move on our grandchild to get our grandchild to us. We need our grandbaby. We need our grandbaby.
Yes.
I mean,
That's how I feel, actually.
I am dying. I am dying to know the tea about the cops in that department that were not hip to Kelsey coming back to duty. I want to know. I'm waiting for it, chat. And Lucifer, no, I didn't see. I have not seen those.
House. He got service of the order, Your Honor, in the sense that they let him go into the house. Okay, he's an adversarial litigant against the owner of that house. He just got an order against her. Keep her away from me. I'm scared of her. The police let him into her home. So there's all kinds of bias. There's all kinds of special treatments.
Said the word bias, finally.
I have to say this from my perspective. Again,
Not arguing it right, though.
That reading the transcripts of these calls that Mr. Elaine was making to the North Andover Police Department,
He misleads
He
them.
was in with the right people. Maybe he was on one date, but he was pretty
Not here.
pissed off on the date he was calling and why.
Because he wasn't used to getting the special treatment he always gotten. And it fits the story entirely.
Because during those calls, he's saying that repeatedly that he's going to take it to a higher level. Meaning, I think somebody even asked him, "What do you mean by that?" And he said, "Talking to the chief or something." And how he was complaining that the North Andover police failed to protect him. All right, so I'm not sure we hear the Commonwealth. I'm not sure.
A lot of that is just the tip of the iceberg.
Are you biased differently?
Right now, you can tell where.
All right, per usual, my wife has nailed it out of the park. Bradl needs to be arguing, not what he's arguing about this curry favor shit, because it's not swaying the judge. You can hear it's not swaying the judge. Allie's assessment is that you should be arguing about the bias that you should be able to expose regarding this guy when he takes the stand. because that's
not
what
the
it
same
is.
bias that Bradl just mentioned. He's still
Right.
talking about bias with the police.
That's
and-
currying favor shit.
Right.
That's not the kind of bias we're talking about here. Yeah,
He'll do
I
anything.
agree. I agree.
My present thinking is, sure, and I agree with that. I agree. He made a statement. His testimony is going to be unless the defendant opens the door, very limited as to the presentation I made a little earlier. If his testimony changes significantly because of that, then it may open up to something different. But having said that, the Commonwealth decided not to prosecute. We're not promising anything. We decided not to prosecute for a specific reason because we believe there isn't a basis to do that, a good faith basis to do that. I can't reiterate that enough, but having said that.
Oh God, this fucking drives me nuts. It's not just that he went into the house, he took her laptop and fucking went and figured out her passwords and went into accounts and stole money. Am I in crazy world? If anybody in the real world does that shit, you are not getting a pass. I am sorry. This is not him getting into the house, grabbing his clothes, grabbing some shit for the baby, and leaving. That's not what this was. This was way beyond that. Every time I keep hearing this guy say what he's saying about why they didn't charge him, it makes me want to throw up in my mouth a little bit. Because there's no rational explanation for it. Unless what Tim Bradl is arguing is true. That this guy's got connections. And then this guy's just being the patsy, coming in saying this bullshit. Which is very much what it seems to be. It's crazy.
What does any of this have to do as to what happened to them up there? Because the counsel is up here 1 minute saying it should be very narrow, very short case about what happened in that room between Patrick Noonan and the defendant, and then all of a sudden wants to litigate a different case about the corruption of the North Andover Police Department.
Tim.
Mr. Iolian's favorable treatment. Well, you can't have it both ways. It's either one or the other. And so that's what I'm a little nervous about now, is that, okay, we start this trial one way, and the representations have been made.
Tim can't wait to stand up and talk. That is the hardest part of being a lawyer. Waiting for your opponent to finish talking when you want to just shit all over whatever they're saying.
Well, but that's because I just interrupted you right while you were. I should have been waiting for you to finish talking.
I know you didn't even have your headphones on.
I know.
That was a real preemptive interruption.
Now I forget what I was going to say because I realized I heard you saying something about being interrupted. I was like, oh wait, I just did that. Oh, you're the one deciding to call him. What the fuck is he saying? You, sir, are deciding to call the what'd you call it? A mine shaft, mine bomb.
A mine shaft, yeah, a field of landmines.
Yes, the field
yeah.
of landmines.
Yeah, no doubt.
And I don't know what for some reason, they want to get him on the stand. So then you're turning what could be a 1-day trial into a fucking 5-day trial.
Because if I'm the judge, I'm turning around and asking him that question. So you're sitting here, counselor, telling me, like, why are we getting into all this shit? He has nothing to do with it. Exactly. So why the fuck are you calling him at all? You know, you're picking the fight.
And albeit I'm saying focus on the other avenue of bias, I agree with everything you said. I still think this proves bias. And I still think him getting a favor, even though he agreed to testify before, but is not before he got on the stand and actually testified, he was given a benefit. And I think that's a benefit that he should be allowed to explore. I was just saying, you know, the judge isn't feeling it.
I mean, the judge isn't feeling it because I just, what is the probative value that this guy brings to the table in any respect as to what happened in those few moments up in that bedroom? Zero.
Now we're taking it to a different place, and that's why the Commonwealth has filed that motion previously.
Okay, so here's the thing. I think where I come out is I have to defer ruling until I hear the direct, or if the Commonwealth were to otherwise open the door. So what I would say is just come to sidebar before you ask those questions. And
I'd be fine with written motion.
Generally speaking, I expressed my view of it, but it wouldn't be fair of me to Ms. Simmons to completely preclude it without hearing the director any of the case. So that's my ruling. Will be deferred until. Sure. Yeah. Sure.
Can I just say, just in response to what my brother said, I was actually going to use that against him, that they can't have it both ways. If you're going to call the witness, I get to cross-examine him.
Right.
That's why I tried to start the hearing with the agreement that I saw. That is, that Mr. Ubatosi saying it was a simple case, Mr. Bradl saying the narrow issue here is it's a simple case, and I want to hold both sides to it. So,
I appreciate.
And that's why his first question was.
I agree that it should be a simple case. I hope it's going to be a simple case. It should be a simple case. But we're even thinking about making it simpler. And, you know, I know we still think with all this jury stuff, you know, we talked about a possible bench trial. I don't know yet. I'm just saying, everything's on the table still. But,
Bench trials on the table
if
still.
If they're going to call too many witnesses, I got to cross-examine too many witnesses. So, you know, it depends on where they're going to go with him. And, you know, he's going to have his comeuppance in family court. And I don't think that I really want to get into too much here. And, if the Commonwealth wants to call him, it's going to happen to the extent you are lesson. Thank you.
okay, so I'm going to.
Here, I
He
just
said-
want to hear. I want to hear Tim say that again.
Yeah, you got to call him. It's going to happen to the extent you allow it, Your Honor.
Yeah, but I love he's going to have his comeuppance in
Yeah.
family court. Say it again, Tim. Say it for those in the back that didn't quite hear you.
Witnesses, I got to cross-examine too many witnesses. So, you know, it depends on where they're going to go with him. And, you know, he's going to have his comeuppance in family court. And I don't think I really want to get into it too much here. And if the Commonwealth wants to call him, it's going to happen to the extent you are lesson. Thank you.
Okay, so I'm going to defer ruling until trial, really until after Mr. Elaine testifies. The defendant should come to sidebar before asking questions related to that. Let me ask on something that Mr. Bradl just that I wanted to ask. Let's just march.
So the judge's first question was like, "Are you guys calling Mr. Elaine?" That's like the judge's first question as soon as he sat down. 'Cause he's
Right.
like, I saw everybody said it's going to be easy. He's like, wait, are you guys going to call Mr. Elaine?
And why? Why would you do that? Can you make me understand? Explain it to me as if I'm 5, because it makes no sense why you'd be calling. All right, so Tiff, thank you. I see it. So these are some messages, purported messages between Justin Elaine's mother, Lisa, and a Stowe police officer.
It piggybacks what Hope said. I heard Justin's mom knows the higher ups. So go ahead.
So this is it. So this is dated July 4, 9:17 a.m. Morning, Kelly. It's Lisa Elaine, Justin's mom. I hope you get to enjoy the 4th of July with your family. I just wanted to give you an update. After interviewing several lawyers, we finally found one last night that we really like.
Wait,
He
who
told
is this to?
This is to a cop, a Stowe cop.
Okay.
Goes unnamed. Well, Kelly. We don't know the last name.
Right.
And it's from Justin's mom. Okay. He told us that the charges are set. Okay. So it should be on the news today. Kelsey is being charged with armed assault to murder and 2 counts of assault with a deadly weapon. It is a horrifically sad and overwhelming situation, but this is a wait, hold on, I had to switch. This is giving us a tiny bit of peace knowing that Justice and sweet baby boo-boo are and will be safe. Thank you again for your knowledge and support. It had meant more than I can express. So there was a typo in there. And then Kelly says, I'm glad you guys feel safe. Always reach out if you guys need anything. Wishing you a happy 4th with your family. And then July 28th, there's another text that looks like it was it's hard to see what it's redacted. And then July 31st, again, Lisa Elaine to this Kelly. Hi, Kelly. I'm sorry to be texting you so late, but we're just going over plans for tomorrow. And Doug, Ashley, and Courtney are going with Justin to court tomorrow. My son, Brendan, is stuck in Chicago, not able to get home due to a flight issue. but I'm going to be here at the house alone with the baby while they are all at court. And I'm wondering if you could just ask for the police to do some extra drive-bys tomorrow morning and throughout the day. We're assuming that Kelsey's whole family. Wait, I got to get to it. We're
Will be in
assuming that
court.
Kelsey's whole family is going to be either at the courthouse or with her, but just in case. I'd rather be extra cautious. Thank you. Heart, heart. I hate this crying. Will do. And then Lisa says, thank you. And then September 4th. Hi, Kelly. It's Lisa. Lisa Lyon, Justin's mom. Sorry to be reaching out, but I just wanted to touch base as tomorrow our lawyer is having Kelsey served with a complaint for custody and support at her parents' house where she is residing due to her getting bail. And let me see, due to her getting bail on September 23rd is the hearing for the extension of the emergency restraining and custody order. We just thought you all should know, especially since her dad has been causing quite the scene in North Andover. Thank you. And then Kelly says, thanks for the update. We keep sliding by your residence. as we know- Yours, because that's where the baby is.
Right, right.
We keep sliding by your residence as we know she was given bail. If any doubt, call 911. Oh, thank you. This is Lisa. Thank you. And we really appreciate you and everyone watching out for us. We're very nervous for Justin and the baby. And I always have my phone on so I can call 911 immediately if need be. We have cameras up and doorbell ones go in Saturday. Thank you for everything. And then Kelly, always, you know where I'm at if you need me. And then Lisa, I truly appreciate you more than you know.
So does anyone know if that Kelly is just a beat cop, a detective, a higher up? Like,
There's more, but
oh,
but
sorry.
wait, there's more.
Wait, there's more.
So November 8th, 1:43 p.m. Hi there. Was that you that just drove by in the police car? Stop in if it is. Smiley face with heart eyes. Not today. I'm off. That was Kelly. Oh, somebody drove by in a police car real slow and was kind of looking in, but I couldn't see who it was, so I thought maybe it was you. Enjoy your day off. Hope you're doing something fun. Thanksgiving Day, November 27th. Happy Thanksgiving. I hope that you have a beautiful day with your family. Know that we are so thankful for you and all you have done for us over these past several months. It has been more than you know. And then Kelly says, have a great day with everyone. Appreciate the text. Happy Thanksgiving. And then January 12th. Hi, Kelly. Happy New Year. And this is on January 12th again. Just wanted you to know that I was thinking of you and that I hope that you had a really nice holiday with your family. Heart. Happy New Year, Kelly says. I have to swing on by and catch up. I hope you are well. Glad the holiday is over and we're in a new year. Moving forward, be well. Always here if you need anything. January 12th reply from Lisa. Oh my gosh. We would love for you to swing by and catch up anytime. Heart emoji. And then January 16th. Morning, Kelly. Hope you're having a good week. I'm reaching out because Monday, Justin is having blank baptized at St. Isidore's at 4 p.m. It is only us, immediate family, the deacon and his wife, our foster child, Milani, and her family, and our moms. But in the court agreement, Kelsey's stepsister, Maddie, is allowed to be there. She is the only one. We are praying the family will respect this and not show up, cause a scene or anything else. But we thought we should reach out to see if maybe if you are on, you could be driving by or close just to make sure it is all okay. If you aren't, maybe you could ask another officer to. Thoughts? And then Kelly, the PD is right there. I don't think we need to drive by. They have been abiding by order. If for some reason they do, tell them it's a private event and call the police. Don't engage past that. Remain calm and walk away. And then Lisa, sounds good. Thank you. So pretty cozy. Pretty cozy.
Sounds like it's just a beat cop, though.
I mean, I don't know. It's like having somebody in there.
Yeah, for sure. For sure.
You know, it's like, I don't know. Oh, let's see.
I mean, they're acting like, what are you afraid of her family for?
He is Lieutenant Kelly A. Barheit. So she's a
she's a
lieutenant.
lieutenant.
Yeah.
That's higher up.
Tie her up. That's pretty high up.
Yeah.
It's
Yeah.
higher than a sarge.
Oh, God, babe, my shoulder.
Oh, baby cakes.
How much time's left?
Hours.
Committed prior good acts. Yes.
Again, I think this would come up more in redirect than in direct of the conflict of matter unit, so I would just ask.
I'm coming up the stretch.
And if we feel it becomes relevant, we'll decide our prior to redirect.
Okay, so I'll defer on that as well. And let's just talk just generally, do you folks, are there any exhibits that you folks think are going to be the subject of strenuous objections and litigation? And if there are, if you could just, let's just get out in front of them. All right. I'm sorry, something that Mr. Bradl just raised. Follow up on it, I just can't recall. All right, so what that leaves is paper 73, which is that was filed this morning and the motion to modify the pretrial conditions. All right, so it's paper 73, defendant's request for change of address. All right, so let's just make sure that we're on the same page, Mr. Bradl. And that is that you're seeking, there is an order in place now that the defendant reside at a particular address in Bethune, with Warren and William Page. So you're seeking what to?
So Judge, can we put a sidebar on some of these issues? Judge?
Sure, absolutely. And if we're going to do that, Ms. Fitzsimmons is going to come up as well.
Thank you very much.
Thank you.
Let's see. We got a little, short. What was that? Ooh, a few minutes.
So, Mr. Bradl, well, let me just go back just because we were at sidebar. The Commonwealth objects. This would mean changing the conditions to basically two conditions. One is to reside at a particular location in Bethune, and second, to reside with Mr. and Mrs. Page. As far as I can see, those are the two conditions that this would impact. And Commonwealth objects to both. Does Commonwealth object to both, or to one, or to all both?
Well, there was a long hearing and a long history to this case. And one of the conditions that the defendant was placed under was that she specifically live, I don't care what house it is, but with her family, with her mother and her stepfather. There was colloquy with her mom that she would take custody of her, and that she would oversee what she was doing, and that she would report to probation if there were any problems. Now she's asking to live on her own, which I think is a marked change to what we've been doing for the past few months. She, in her affidavit, it's basically.
Oh, so in fairness, all I wanted was a yes or no. So no, that's fine. Because I want to give Mr. Bradl an opportunity to argue his motion before you. I just wanted to make sure that there is, so it seems like you oppose both, or is it more the supervisory role of the parents?
Well, which resident, if they could move the entire family to another house, I don't care about that.
Okay.
You know, as long as probation is fine with it.
So, Mr. Bradl, I'll hear you.
Yes, sir. Thank you very much. So, Your Honor, Ms. Fitzsimmons is a 28-year-old adult. She had this order at a different time in the case. And, I'm not going to get into too much, okay, but this order was entered in very suspect circumstances. And I know what you're gonna say, so I'm
No,
sorry.
no, it's just not helpful because, but let me ask, Commonwealth, are you objecting to me hearing this motion?
I don't think there's any changed circumstances, so I am in that regard. So,
But the concept of me ruling on the motion in the sense of whether there's changed circumstances, you folks don't object to that. All right, go ahead.
So Judge, and there's actually another aspect to this that we're asking to that kind of go hand in hand, and that is that we're asking also, I'm asking you to lift the restriction from the Superior Court, something I've never seen, where the Superior Court justice said that she can't go to family court and do anything. It doesn't matter what family court says about custody or visitation. The experts that do this, that's their core function.
Where does the order say
The
that?
order here is that she has to stay away from the child and that she, regardless of any probate court orders. I can't point it to you this very second, but it is in writing in one of,
No,
yeah,
it's there.
okay,
I
so,
want to make sure that we're on the same starting point.
Right.
So we have a written motion at paper 73 for Jazz
Yes.
after the change of those other two.
right,
Orally, you're moving to vacate the order, so much of the order that says, let's see, have no contact, direct or indirect with own child.
and only to the extent to say, subject to deferring to probate court. So subject to probate court orders, that's all.
Commonwealth,
well, there's also a restraining order out there that has never been challenged at this point, so like.
but if, in other words, if I were to vacate that and make it, so, she's already, Ms. Fitzsimmons is already ordered to obey all orders, court orders.
I would leave that up to the court.
Okay.
Sorry, I would leave that to your discretion.
Okay, all right, so that's easy. I'm going to vacate so much of the pretrial conditions that requires no contact, indirect or direct with the child. And again, only because since the passage of a long time,
Yes.
we now know, because the Commonwealth provided dockets, that there is ongoing, at least a case has been opened related to the well-being of the child in the probate family court. They're the experts. But I want to say that all that this initially did when it was entered was essentially ordering her to comply with the restraining order, because the restraining order had, it wasn't Judge McCarthy, it was the probate court judge that had granted.
The restraining
Right, okay. So I will vacate that.
Thank you.
And,
And I could just tell you, just so you know, Judge, the motion for temporary orders has been filed, and the hearing on that is 4-2. So it's probably after this trial.
can I ask something more out of intellectual curiosity? The Commonwealth in your motion provided the docket entries of the custody parenting case, but it didn't mention, that those docket entries didn't mention the restraining order at all. Is that because it was taken out under a different docket number?
Correct.
Okay.
It's a separate case. I actually represent Ms. Fitzsimmons on the restraining order in family court, and my colleague, Ms. Hess, represents her.
But it's a completely different docket number. That's why I wasn't seeing it on the docket. All right, so.
And in that date, Judge, just so you know, 414 is for the restraining order, so.
All right, so I'm going to vacate that, and Mr. Boyd, just remind me I need to, so you've docketed the orders, the order of pretrial conditions.
I thought that he said in the motion that the temporary restraining order did not encompass the child.
What do you mean?
When we were just reading all of that earlier, I thought it said that the initial temporary, or what we would call an order of protection, I guess what they call a
I thought they
restraining
were
order.
arguing that, but I don't know if that was. I mean,
Because
either way,
this judge is saying, just so you guys know, the judge's order in this case wasn't having any effect other than that she's required to abide by the restraining order. I don't think that's exactly true. And
well, I mean, the question is, was the baby a protected party?
right, I could have sworn that you said the baby was not a protected party, not you, but when you read.
Yeah.
But Bradl said something very different. He said there was an order at some time where this judge said she is barred from having contact with the baby, and regardless of anything that happens
But I
in
think that was
family court.
I think that was in one of the conditions of bail.
Well, that's very different than what this judge sees it as well. Just so everyone knows, the only thing that judge did was, make sure that you abide by the restraining order.
You're talking about the woman that preceded this judge on the bench?
This judge just said that the only thing that other judge did was put a condition in that made her abide by the restraining order. And Bradl said the words, there's an a written order somewhere that says she cannot see that child regardless of what anything that happens in family court or any other court order, that she is barred from having contact with the kid. And then this judge just said the words. The only thing the old circuit court judge did was obligate you to comply with the restraining order. I don't know. And I could have sworn when we were reading the petition that it said the baby was not a protected party.
Let's see if they flush.
74 and this. All right, so
And that date, Judge, just so you know,
under a different document.
correct.
It was
Okay.
It's a separate case. I actually represent Ms. Fitzsimmons on the restraining order in family court, and my colleague, Ms. Hess, represents her
Okay,
for
so
custody.
completely different document, that's why I went to see documents. All right, so
All right, so that explains it. The judge said he didn't see whatever Bradl's referring to because it's on a different docket. I'm
Okay.
guessing.
And that date, Judge, just so you know, 4/14 is for the restraining order itself.
all right, so I'm going to vacate that, and Mr. Boyd, just remind me, I need to, so you've docketed the orders.
She was, like, shaking, starting to tear up.
GPS at 75, so I'll need to just change those, but let me wait until I decide the other issue. Let me hear you on that.
Thank you, Judge. So Ms. Fitzsimmons is preparing to be able to offer the family court a viable, good situation for whatever custody visitation she can get. And she needs to do that in advance of the 4/2 and 4/14 hearings, so that she can go to family court and say, you know, I now have a home, I have a good, you know, that's the first question the family court judge would say. Well, if I give you something, Ms. Fitzsimmons, where are you going to be? Where's the baby? And we want her to be able to say, not that I'm at my family home in my high school bedroom. I want to be able, for her to be able to say, I have a wonderful townhouse, plenty of room, fenced in yard, great situation, and I'm ready to go, Your Honor. And you know, we'll also proffer Dr. Zeisel's report.
We're still at 1.25. We never left it.
And I'm assuming he's going to ask for freedom to travel, to do custody exchanges, and to maybe take the baby to recreate, to the freaking park. Leave the house.
Sure. All right. So there's one other thing Tiff sent. Thank you very much. And it is an email that's of interest. And it's from Lieutenant Kelly Barheit. Okay. And it's to all kinds of cops, dispatchers, sergeants, supervisors, officers,
Wow.
detectives, officer, prosecutor, all kinds of mofos. Okay. So subject, evening, everyone. There was an officer involved shooting in North Andover this evening where Officer Kelsey Fitzsimmons shot another police officer in her agency after a restraining order was taken out by her boyfriend, Justin Lyon.
Wait, it says that?
Yeah, I'm reading it. Yes, this is where I'll read it again just to make sure that I'm not fucking it up. Okay, where Officer Kelsey Fitzsimmons shot another police officer in her agency after a restraining order was taken out by her boyfriend, Justice Elaine.
Justice, she wrote?
Justin, whatever.
Oh, I didn't. I was just saying.
Come
'cause I
on,
thought
dude.
She knew the family well. It was going. It had a reason I asked. I'm sorry.
Okay. Oh yeah. Of Maple Street of Stowe. So it was involving a custody battle between Elaine and Fitzsimmons.
Custody battle.
Right.
Mm-hmm.
And
That's
when
supposed to
her
be.
agency responded to her home to retrieve the firearms and the baby, she shot the police officer. Boy, she doubled down on it. And Justin fled the home with the child. She has been med flighted, and status at this time is unknown. MSP detectives have taken over the case. There is a real concern that her parents will try and come to 28 Maple Street. Please make sure there are checks several times per shift until otherwise notified. These checks are to be logged. If a 911 call comes in, this residence has been flagged as a caution. Make sure that you respond immediately and safely. The family is traumatized over the incident and are afraid right now for the safety of Justin and the infant. If any calls come in, for questions or information about this incident, please forward them to me so I can give them all the wrong information, the completely inaccurate information about what happened.
Wow.
Uh,
I mean, I know it doesn't say that stuff. but
12
you
OF is the report number. Please read so you have the information.
I can see that what I just said is totally fucking wrong.
Wow.
Complete dissimulation.
So she put
Wow.
everybody on blast with the fact that Kelsey shot somebody. Wow, that's fucked.
So,
And
yeah,
this is the gal. This
she's
is
the higher up.
higher up.
Yeah.
Be
The
careful.
family had it in with the higher ups.
Clearly.
I mean, the judge is like, it makes no sense though. Why are they giving this guy, but he doesn't know stuff. And that's why I'm saying they need to file another written motion to make it clear, that this is not what it appears on its face, Your Honor.
Well, I mean, Bradl all but said it.
Yeah.
He's like, oh,
But they need to flesh it out, I think. And
I
and,
got
and
shit. I
to
got
tell you-
stuff.
to tell you
I
the
heard
truth,
things.
I think they just need to flesh out what you and I were talking about
agree.
and leave that other one in their back pocket if they want it.
What things you heard? I heard things. What things you heard?
Yeah.
And when I say that those things we were talking about, but just the bias of he will go to any extent, he will do anything to get this woman locked away. To
He will
take this
stop
baby.
at nothing.
He will stop at nothing. And I mentioned earlier that I was talking about my ex post. I've come to terms with not calling it Twitter anymore. That about Elaine being put on leave, and that initially I thought it was because of the whole breaking in, stealing all her shit, like conduct unbecoming. But then, based on that affidavit and the timing, it seems way more tied to his drinking the cooking wine at work and all his drug and alcohol abuse.
Oh, man.
That shit's out there.
This is a good thing for her, that this is something that is consistent with her very bright future, that's something that is appropriate. This was a 4-month-old child who's now a year-old child, over a year-old, and that this needs to happen for so many reasons, Your Honor, that I won't get into, but she needs to have a situation that's ready. And I think we have expert clinical evidence to show that in the present circumstance, she's ready for that. And we were asking the court to get on that bus and help her in this sense, so that she's ready when this is over with. She's ready. She's in the best possible position she can be in to go to probate court just a week or two later with this in place. If it's not in place, God knows it's a nightmare scenario, Your Honor, because I'm sure probate court dates are like, they'll without batting an eye, they'll set like an August 8th, and Ms. Fitzsimmons will be sitting here, So
See, pause it a
Trying
second.
to get all of our ducks in a row as best we can.
That's fucking bullshit. That's why I was asking him, like, why in the fuck is this not until, April? There was like an April 14th. And he's saying, Your Honor, this could be scheduled out till April. And the judge jokes back of what year? That's how backed up their family courts are. Family courts are supposed to be expedited courts. That is their,
especially in dealing with children.
exactly. When you're dealing with custody, look, even money can be, people need it expedited. All right, that maybe, but when you're dealing with when a mother or a father sees their child, shit needs to be expedited, because it is beyond outrageous that it has been 9 months since this mother has seen this child.
It's
I've
almost been a
never
year.
seen a family court
It's almost
doesn't
been a
say
year.
at
More
least
than 9 months.
right, at least supervised visitation, even if it's with a social worker. I mean, for God's sake, something. It's so outrageous, and it can never be undone. It's heartbreaking, really.
It really is.
And this would be something that I don't think asks too much. And, she's agreeing, and you see in her letter and in my motion that she's saying, I don't want my lawyers to disturb any of this other stuff, about house arrest and scram and, the 2-hour notice, which we appreciate very much, to come see us. She doesn't want to disturb anything else. She just wants to change her address and live like grown.
So can I
And
ask
be able to
something,
pick up her
Mr.
kid.
Brayden? So there was much litigation prior to my involvement related to the alcohol testing, smear testing. And why isn't alcohol use mentioned at all in Dr. Zeisel's report? But I think in either of his reports.
So, because it's something that, and I'll give you my real answer,
That's all I want.
it's something that was imposed on her to stick it to her, to punish her, Your Honor. There's no alcohol whatsoever in this case. There's no pattern of anything. It's a total red herring, and it never should have happened. And I am furious about it. It is absolutely beyond the pale that she was tortured with that scram device, Your Honor, and I'm furious about it, so I'm sorry, but I'm talking about, it's baseless, is my answer, sorry.
All right, so leaving aside your argument about whether it's baseless or not, I have to tell you that I read all of the impounded documents that the judge relied on in fashioning the order, and alcohol was mentioned by Ms. Fitzsimmons' own friends that were at that. So now let me say this.
At one party.
So my only point is that it's. So your position basically, actually you answered it. You're basically, Dr. Zeisel didn't weigh in on it because he presumably doesn't think it's an issue.
And he's here, so like I said, if you want to put him under oath and hear from him, I'm sure Dr. Zeisel will echo everything I'm saying about how there's no evidence, nothing's evident about any alcohol issue in terms of, at a bachelorette party, a week or a few days earlier, whatever, fine. But as a basis for long-term, monitoring is outrageous to me. And the only other thing in the record, Judge, we'll talk about a reach, 2018 in like Myrtle Beach or something.
Yeah.
And that,
this isn't helpful.
And that was expunged.
I realize that I kind of opened the door.
I'm sorry. He's here, Judge. If you want to hear from him, you can get some more evidence on it. The alcohol issue really is.
Nice to see you.
Thank you. I've been well. How about you?
I've been excellent.
That's great.
I should say one last point, Judge, I even missed. Ms. Fitzsimmons was breastfeeding at this time. She's not drinking. She doesn't have an alcohol problem. She's raising her baby. She's a wonderful mom. And this whole thing is inferior. Sorry.
No, there's nothing to be sorry about, Mr. Bradl. You're an advocate, and a good advocate for your client. And the judge asked you, and you answered. And when the judge asked you, then you didn't want to hear the answer. I get it. But the point is, really, in all seriousness, the point is you're not seeking to change the scram.
Right.
Right? And so can you just tell me, how does the scram work? Is it random or is it probation? Hi, how are you?
Morning, Your Honor. Well, good afternoon.
Yeah, come on up. And you are again?
Alexander Platt, probation.
I'm sorry?
Alexander Platt.
Hi, okay. And do you want to swear?
If you raise your right hand, you solemnly swear to make true answers to such questions put you by the court or upon directions.
God, what a better
I'm
judge.
sorry.
I see nose rings are still a pretty big thing out there in Mass, huh? Y'all
I
like
can't
your nose
see
rings?
anything. What are you talking about?
She's got like a fucking nose ring, like one of the bull ones hanging out
I don't
here.
see it.
And then one of Kelsey's has like the side nostril. Trust me.
That's all right. They can have them.
I mean, I'm just saying. I thought those were like super 2010.
That before this morning at the other here. Officer Hunt, are you supervising Ms. Fitzsimmons?
I'm not, Your Honor. It's P.O. Scrunchy in Salem.
Who is it?
P.O. Scrunchy.
How do you spell
Scrunchy.
that?
SCRENCI.
All right, another officer that I'm not familiar with. So what is the report back? Has she been in compliance?
She has, Your Honor.
Maybe she doesn't have one.
All right.
I can't tell. Maybe she just has like a little sweat there on that thing.
Okay, let's
She was 7 minutes late to curfew on March 10th, but she had informed Elmo ahead of time, and points show that she was stuck in traffic coming back from an attorney's appointment. She also missed 2 scram tests, but then passed the immediate on-demand test. So she's passed all her scram tests.
Okay.
So other than those minor incidences, she's been in full compliance.
And the scram, how does it work, or how is it working in this case? Are they random?
They are random.
Okay, so what happens? Does something go off on the device or something?
That's correct, Your Honor. A noise alerts her that a test needs to be taken, and then she has to take the test.
Okay, is that something that, again, this is more intellectual curiosity because I haven't really had the opportunity to learn about how exactly the scram device works, but I think it's important for me to know because it's one of the more significant parts of the pre-propagation work. But what happens for the notification? Is it the GPS monitoring bracelet that goes off that tells?
Those are separate, Your Honor, but Elmo supervises both of those.
Okay, so what happens? How does Ms. Fitzsimmons know that it's time to do a scram test?
It alerts her, a noise goes off.
So, and what is this device? The device is a breathalyzer or something?
Essentially, yes, yes, Your Honor. There's a straw that she has to blow into. It takes her picture so it knows it's her. And that's how, and then the feel like Wi-Fi essentially
So does that,
recording it?
does that mean that she has to have that with her when,
at all times.
okay, so when she leaves to go to doctor's appointments?
Yeah, so Judge, I got it right here. It leaves from 7 a.m. to 11 p.m. all the time, and she blows into it, and it took her months to be able to blow into it without a lot of pain, and she can do it now because her rib is healing up. Her rib was blown apart in this shooting, and she can breathe now, and she can do it. And it gets on her from 7 in the morning till 11 at night. And it also has a GPS component to it as well. So she's on double GPS.
Roughly, I know it's random, how many times a week do you know that it asks? Is there?
I'm not positive of Ms. Fitzsimmons, but I believe probably does around 50 tests every 2 weeks.
Really?
I believe she has many random tests a day as ordered.
Judge, I think it's for Ms. Fitzsimmons, I think it's about 4 times a day it goes on.
And pass with flying colors as far as we.
Correct, Your Honor.
Good. All right, Mr. Brady, is there anything else on, I'm sorry. anything
Pause
else
real
on,
quick.
Officer Hunt that I should know about her?
Pause real quick.
I heard
So
you, Bay.
you noticed that she said, the probation officer said, well, she missed 2, but then she passed the one immediately after. And the judge is still saying, okay, and she's passed with flying colors. The other judge acted like the sky was falling.
Diametric opposite.
Yeah.
Yeah.
All right. Go ahead.
Pretrial conditions?
No, Your Honor, she's been in full compliance and in communication with probation.
All right.
So she's been a great probation judge. I appreciate you inquiring about that on your own. And, you know, it's just a step in the right direction for her. It's not a lot to ask.
DKK.
It's something that I know based on my interactions with her over the last 10 months that, you know, she's very motivated to not do anything in contravention of the court.
So what is, actually, I'm not going to ask you this because I know what the answer is. Mr. Gutowski or Ms. Moriarty, what was the purpose of ordering Ms. Fitzsimmons to be in the custody, or to, really doesn't say custody, to reside with Warren and William Page? But
Well, I can't speak for Judge McCarthy, but I was there. This was not something that I agreed to, I encouraged or anything like that.
Right.
It sounded like that because of the situation in its entirety, including test taken from her high school friend that she's had an alcohol problem and an aggression problem since then.
I saw it.
That the judge thought it was appropriate for the mother to monitor her. So she made sure she does everything, including making sure there's no weapons, no dangerous weapons, nothing in the house that would be considered dangerous. And so that is what Lauren Page, the mother, had sworn that she would do. And I think that answers your question as best as I can answer it.
Okay, and tell me about your objection.
My objection is, we're all glad she's doing well, but why are we going to mess with it at this point? We have a trial in 10 days, which is going to be a very stressful time in her life, I'm sure, that we're coming upon. There have been no change in circumstances to suggest that, no real change in circumstances to suggest that this is an appropriate reason to change anything or a time to change anything. I think all that could happen here is we mess something up and it messes with the trial date. Or she hurts herself or she hurts someone else. That's what this is about. These conditions were put in place for a reason. I would suggest they were ultimately fair. I just don't understand why, if in her letter to the court,
Did she sign that?
Yeah.
her primary reason for this request is in preparation for my notification of my child. We're talking 2 weeks. 2 weeks.
What do they give a
From
fuck?
the time of today to basically, we could be finished if it's a streamlined trial. Why would if it's not broke, let's not fix it.
Well, but from her perspective, it is broken.
Yeah.
Sure. In my perspective and from the unbiased really look at this, it's not broke. She's doing everything the court has asked her to do, which she should be doing. And so what's the change circumstances at this point?
That she's trying to get her baby.
Change circumstances.
I point to Dr. Zeisel's report, her letter, the passage of time, the fact that we're in a trial posture, and sort of maybe why don't we analogize it to, when someone asks you to remand a guy from Pittsfield to Essex County House, it's like counsel for the Commonwealth is answering my own question, which is, it's a stressful time because she's in a difficult situation and it's hard for her to prepare. If she has her own home, it's much easier. She can come and go. She can come and go. She has a whole place. She can focus on other things when she wants. You know, it's just a, I don't want to make too much of it, Judge. She's just going to go to an appropriate home, and it helps her in her family court efforts that, you know, like I said, I don't want to push it off months and months if we're not ready on that occasion. So
I'm sorry, but
I'm alluding to what I mentioned earlier, Your Honor, about how on the 2nd and the 14th of April, we're going to be in family court. And I want to be able to say that she's been in her house for a couple of weeks. She has a great situation. She's been setting it up, and, you know, it'll just take a lot of the, you know, it'll uncap the tea kettle, and a lot of steam will escape here if she could just kind of be in her own place.
that would be grounds that would support my revising or modifying those two conditions. But I can say that I think the teachings of the SJC's cases under 50 today often are that the passage of time can be a changed circumstance. And
There you go.
Here, there is arguably a changed circumstance because Dr. Seisel has said that her mental health has improved significantly. Because my memory is that in the first report that Dr. Seisel wrote that's in the file that's impounded, he did imply or mention that she didn't contest that she had been suffering from mental health concerns at the time.
Yes.
And in directly after. So I do see, I guess the long story short is I do see sufficient change in circumstances. The question is whether, whether the supervision by her parents is something that I would change on this record. And so does Ms. Fitzsimmons have an address in mind?
Yes, Judge, it's all set. Even the lease is signed.
When would she move?
As soon as you're ready, Judge. She has custody of the place. Whatever the work is, she's ready to go.
And
it's in Essex County. I can certainly give you the address, obviously.
right, and she's amenable to having probation inspect the place prior to her move. Yes.
Yeah. Oh, absolutely. I think that's.
And how about if I were to order visits to
No objection.
to ensure compliance with the no weapons and et cetera.
No objection.
So, sorry, Officer Hunt again, come back up. So can you tell me if I were to order some kind of a visit by probation before the defendant were to move into the location to make sure that it is placed, at least from what is observed, that it doesn't have any weapons. You can see what it's after. No weapons brought into home. So weapons being pretty broad. Is that something that the probation department can do?
Absolutely, Your Honor.
And how about, I know that home visits happen all the time when someone is on post-trial probation. Is it something that you folks see occasionally, at least on pre-trial?
I'm aware of one case we've had where we have done it, so I believe it's possible, but I would like to double check with the supervisor. As for the home visit, that could be.
Is that post-trial yet?
Home visit to check. We could do that by the end.
Is Officer Scrunchy available for at least maybe for you to communicate with about that aspect?
Yeah, I can contact her right now.
So it seems to me that, and again, I don't want to go back and forth on this. I read all of what the original judge had before her, and all of these orders were well supported. They were orders that I would have issued at the time. They're orders that a single justice affirmed. They're orders that the SJC affirmed. I don't want to relitigate that, but I also believe that there's sufficient grounds to consider allowing the move and allowing the termination of the supervision, I guess, or the residing with the parents, so long as the probation department could monitor, and it would be by surprise monitoring. Officer Hunt, I don't know if you heard that. So I want these visits to be a surprise.
That's no problem, Your Honor. I also just spoke with my supervisor, and she said as long as it's a court order.
Either side want to be heard any further?
Judge, I just should say that her PO is aware of this request and it's been discussed. And, you know, I shouldn't say that she agrees with it. I just say that she's fine with it in the sense of whatever the court order, she's happy to implement.
Anything else, Commonwealth?
Just back off, Commonwealth. The fuck do you care where she
I'm
lives?
going to allow the change, subject to an inspection by the probation department prior to the move.
It's about fucking time. It's about fucking time. Good for you, Kelsey. Good for you. Long, long overdue.
I'm not ready to start clapping. I'm pissed about it taking another
place. And the
step.
inspection will be for weapons and also alcohol. You may as well look for that. It will be subject to
It's going to be empty.
inspections,
It seems like.
random inspections by the probation department. I think what it may make sense at this point is for me, so which would also mean that the DPS supervision conditions would need to be changed. I think it makes sense, Officer Hunt and counsel, for me to just issue a new order rather than write on this. I would carry over all of the orders. No, you know what? I don't think it's necessary. Do you have do you want to bring the sidebar on the address? Or is it something that you can provide?
I just provided to probation, Judge.
Yeah, but I need to keep sure. Everybody come on over to sidebar, please.
Right. Let's not put her address out on blast. Bloop, bloop, bloop. Wow.
We're getting close, eh?
All right, so I am going to allow that modification for the reasons that I've already described, both open court and at sidebar. I need to just write it up. We'll impound the new address. I'd ask all counsel, as I said at sidebar, to continue to keep in mind that we want our jury pool to be as made up of as indifferent of a group of folks as we can.
I mean, Dad's happy for them too. I mean, they haven't been able to see their grandkid,
Oh, yeah.
right? I
It's
mean,
the most outrageous thing I've ever heard.
fucking
It's-
insane. What a big day. What a long, long overdue, huge day for Kelsey. It's
You know,
like,
do me a favor. Let's not start getting too excited until we see what happens on whatever these two dates are, because it sounds like their family court better fucking do something and not continue to postpone and drag ass.
yeah, here.
But yes, he has given her the
The
window,
avenue. Yes.
right? The avenue. Get a place, have a nice house.
Yeah.
And there's not a restriction that there's no contact in this court anymore. But I'm horrified about their family court out there. Outrage. It's an outrage.
And that's what my expectation is going forward. All right, so I need to change that, which I'll do. Anything else, folks?
I filed another final certificate of compliance, so I'm expecting any moment council's reciprocal discovery.
So, when you say, is that something, so is it something that I need to write in on, or are you just making a record?
Just making a record.
I'm sorry, I missed it, Judge.
Mr. Gubertosi reported that he filed a final certificate of compliance under Rule 14, and that he's hopeful that.
I think we're there. There's a couple little things, but I'm not going to make any show.
All right, so.
Thank you.
All right, but also I need, I appreciate the sending of the joint witness / private names list, but there's a bunch of names on there that don't have towns or cities associated with them.
Yes, as counsel said, as sidebar, there's a safety concern in this case based on things that have happened. So I will get those in court before the trial.
All right, so but how do we handle? I want to provide enough information for the potential jurors to look at that list and say whether they know a person.
Look at a town.
Okay, and then but are you suggesting that that be impounded?
No.
Okay. So all right, so
Why not?
the missing. You folks will get, will run down the missing cities and towns of the folks that don't have them on that list.
I have them, and I'll supply them to the court.
And Mr. Brado, given how close we are to the trial, when you said that something to the effect that there was a couple of little things that perhaps, the bottom line is, are you prepared now to disclose whatever it is that you're required to disclose?
Yes.
And I'd ask you to do that as soon as possible so we can keep the trial on schedule.
Sure.
All right, and let me just see if there's anything else. This is So, in a perfect world, we reconvene to talk about the juror questionnaire. Which we could. Yeah. So are you folks, would you folks be available on Monday afternoons? By then I disseminate the draft juror questionnaire. That's all that we would go over. And you, Ian, hold on a second. Ian, you can appear by Zoom if that would be easier for you folks.
Okay, if we're only doing the questionnaire, yes. That's fine.
Available, yes.
All right. So in other words, no surprises from the Commonwealth.
I'm not expecting any.
I can't, we'll all be surprised if there's surprises. All right, so I'll, that means I have some work to do and get that out to you. Mr. Roy, you have their email addresses?
Yeah. Did you say 2 o'clock Monday? 2 o'clock.
Whatever Mr. Roy said. So. All right, so I need to, I'm going to step off. I need to write up.
All right, bloop bloop us, baby.
Which I will do if you want to just hold tight.
Thank you.
2 p.m. this Monday is the. All right, so we'll stay in recess. See you then.
All right.
All right.
Bloop bloop us. He's coming back. That's the doctor. There's Aiden. We're just eavesdropping now, huh? All right, we can bloop bloop. Babe, I don't need to see them talking. No, the judge said he was coming back. No?
All right, we made
I
it.
thought the judge said he was coming back.
I don't think so. He recessed for the day.
Oh, I thought he said he was gonna. Okay.
Well, some outdoor shit. That's it.
All right.
That's it. That's all. That's
All right.
all.
Welcome.
Folks.
We've got lots of new members, so get to welcoming some people.
Oh yeah, Firecracker 316. Family hug. We love
Wookie,
you.
my mistake. Cat from
Aw,
Canada.
Family hugs to y'all. We love
Wait,
that.
wait, there's some more. Hold on.
Hey, please, y'all, make sure to like, share, and subscribe.
Song Bits, Laura.
We had a great crowd here today. I'd like to get some new subs in there.
Wait, we got some
Our
Cat
subs only went up
Randall.
30.
Come on, we're still giving hugs to the family. New family.
Family hugs. I gotta grift. I gotta get that
And
shit out there.
Strains Credulity.
What? Credulity.
Credulity.
Oh,
I can't even talk.
family hug.
Hey, look at that.
What?
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 Look at Ellen. Can't see the thing?
Oh, thank you so much
No,
for
no.
member for 28 months.
28 months.
That's another
Wow. Oh, gee.
Not everybody
Thank
can
you.
be Ellen.
Not everyone can be Ellen.
Can be Ellen.
Thank you so much for your coverage, for covering Kelsey's case. Well, thank you for your continued support. And Donnie, not Wahlberg, thank you.
Aw,
for gifting
family
5
hugs
members.
for all the new members. Thank you.
Yes. Bestie Boniface. Is that how we decided last time?
Yeah, or Boniface.
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 I will watch you all no matter what you talk about. Well, thank you.
We appreciate
And
that.
Lindsay Bay, member for 20 months. Thank you for your continued support.
Oh, we
Thanks,
thank you.
DD. For Kelsey, this case was and is a travesty. Complete disadulation.
Indeed. Well, it's at least the criminal side of it's coming to an end here.
Ellen comes back at us. Thanks for your generosity again. What happened to Kelsey is so horrifying. Her baby was snatched. She was shot, robbed, put in jail, put back in jail again, and charged with a crime that usually results in probation, all without a chance to be heard. Yeah. Did they drop the murder, some assault murder, attempt murder
It's
she mentioned?
one charge, yeah.
Yeah, I was like, what?
Yeah, it's the assault charge. That's it.
Rami in Mass, member for 10 months. Bob the Jingle King.
Oh yeah, baby.
Facts.
Oh yeah.
Thanks for your continued support.
Oh yeah.
Rumpled foreskin. Thanks for your continued for your
That's a good
support.
one. That is a good one. I'm gonna give a tiny hand
Holy
clap for
shit.
that one. Oh yeah.
Can
Oh,
you
yeah.
imagine what
Oh, yeah.
that Noonan
Oh, yeah.
Noon judge is thinking and feeling right now? No. I mean, he went out of his way to say, I think everything the other judge did was right, but I'm
I
about to
thought you
undo it.
were trying to say nincompoop there. I didn't know what the hell you were doing.
Nin.
Tracy Cooley, $2. He was in the basement when it happened. Thank you. I did not know that. I was not aware of that. Julie Jensen, $10.
Oh,
Thank you very much. I
I
watched one of
mentioned that.
Mel's streams when she showed Kelsey's home. Oh yeah, we saw that.
Thanks.
Cop said she grabbed the gun behind the bed. Oh, okay.
Door wasn't there.
Yep. Jalapiciano. I feel like I'd crushed that. Jalapiciano. Hey,
Picciano.
I'm behind the thanks for thanks for covering. I was put in the hospital by someone I
Oh.
was dating / shared a child with. Took me to court visitation. It was approved because he never hurt the child. This case is awful. Yeah, I mean,
A lot of
sadly, the reality of family court is it is a fucking nightmare.
But, when people injure their spouse in front of the child, when the child's in the house, exposes the child to the violence, that is to be taken into account when you're deciding whether they did anything that is, a detriment to the child. So,
Oh
you
yeah.
know, but
I
yeah,
mean,
that's awful.
I mean,
That
we've had
happened.
clients go through just absolute nightmares, years of not being able to see their kids. It's a whole thing. Family court is a big old mess in general, not just in Mass, but in every state in the union. The whole guardian ad litem thing with whatever therapists or counselors they send people. It doesn't work well. It just
No,
doesn't.
and people are people. You get shit therapists, shit GALs,
Yeah,
shit,
you're gonna people that just aren't doing the job and or whatever, they have a bias, and it's like trying to
music.
convince a judge when that's all the judge has to base their opinion on. It's brutal.
It's brutal. Music to my soul. I love that handle. Love it. It's probably best for Kelsey that Corey Richardson's trial is going to the jury so it won't overlap with hers.
Agreed.
Kelsey's trial deserves full attention.
Agreed.
Yes.
Yeah, plus Kelsey is way better human being than old Corey. Even if Corey didn't murder, she still sucked pretty hard.
Yeah. Crazy cat lady. Thank you for your continued support. And we talked about that. Oh, Justin's mommy wants to be the baby's mommy, in my opinion.
No
Seems
doubt.
that way.
I'm with you.
All right. Soap. Thanks for your support. Hey guys, 5 a.m. here in Australia. Couldn't sleep, so I thought I'd hang with you while set up on my couch with my cats. This
Aw.
is such an important case that I've been obsessively following since day dot. Thank you.
Well, thank you for your
Thank you.
generosity and thank you for being here. And I think I
And
saw you followed me on the Twitter machine. I saw that. I saw your little kitty icon or whatever the hell they call that avatar.
Rumpled Foreskin came back at us. Thanks for your support.
Foreskin.
If that day don't blow your wig off, I don't know what will. Yep.
It was a good day. Good day.
This
Long
is
time ago.
outrageous. Program gamer. Oh, member for 13 months. Thanks for your continued support. Glad you're covering this. Thank you. Birdman says, oh, we did that one, but he comes
Yeah.
back. He comes back to to come back at me when I said his wife was still gone.
Oh, yeah.
Made of questions. What answers do you guys look for these questions? She's talking about, or she was talking about the questions from the jury is we want the answer to be
Truthful.
no, well, truthful, yes. But the answer we want to
Truthful.
keep you on is your truthful answer that you are not going to, you don't think someone's guilty just because they got arrested, or, what would be the greatest answer is I used to always think that, but my mind has been changed and I realize you've got to wait.
Because I watched Defense Diaries and they
'Cause I
totally
watched
changed my
Defense
perspective
Diaries.
on shit.
It totally changed it.
That's what we do over here. It's all about, like, you can agree or disagree with us, but if we cause you to think about things, even if you don't agree at the end of the day, it's all about the exercise of thinking and
Yes.
hearing a different side and
And
perspective.
then being like, all right,
and having it provoke
I
a thought.
I see your points, but I'm going to stick with the way I think. That's okay
That's
too.
totally fair.
As long as
Totally
you
fair.
process it.
Yep.
Sumo, I would like to know the same damn thing. Is it just pride that makes this prosecutor argue against her bail conditions? What the fuck does he care if she moves to a better house? What
just
does
being
she has been a cop. She has never broken the law before.
I like to call it dick facery.
Yes.
As opposed to pride. Little
Yes. Dick facery. Yes.
Dick facery. Yes.
Elaine Burris. Is that the play off of Elaine Bennis?
Or her name's Elaine Burris.
Or your name's Elaine Burris. I was shocked to learn that the folks at the PD knew what Justin was doing while Kelsey was at the PD, with the baby getting recertification in CPR for her to return to work. I mean, it's kind of unusual. You don't go ahead of time and tell the police, hey, by the way, I'm getting an order of protection. It's definitely raises some eyebrows. Like afterwards, sure, I have an order of protection. I'm going to be bringing it down soon. But yeah, agreed. Tracy Cooley says another officer has made sexual harassment charges against the chief. So the department might just be sexist and not really want snake female officers. Yeah, for sure. For sure.
Or for show.
For show. Faux show.
For show.
Ellen comes back. Thanks again for your support. Yeah, Kelsey's dad caused quite the whatever by installing new surveillance. Yeah. He's real uppity, that one. Real uppity. We did read the coming back again, Ellen. We did read the lying insane emails.
We did.
And then Tracy said,
thank you for those, Tiff. We appreciate that.
Yeah. Tracy said, not the original judge, the crazy judge added that. Yes, I understood that with the bail condition he was talking. And this is Birdman coming back saying the cop is McCarthy Noonan. The last judge was McCarthy Neiman. Looks like an Irish conspiracy to me. Side note, I'm on my best behavior, Allie.
Well done. Well done.
Wow. Ellen has had quite a go of it today. Thank you. There's one more email from the same in which law enforcement correctly, Freudian slippy, identifies Kelsey as the victim, but goes on to claim that Kelsey, still in the hospital, will be charged for violating restraining order through counsel. That is the stupidest thing I've ever heard. I read that and I thought, you know what? I had a woman try to say that once, like, well, why can his lawyer contact me? And the judge is like, well, you represent yourself. And so the lawyer can contact you and, like you got to get mailed shit and you're getting phone calls. I don't know what the facts are behind that, but it sounds stupid. So thanks for letting us know, Ellen. And then Amanda says, thank you for spending your Saturday with us.
Our pleasure.
Yeah.
Thank you guys for spending your Saturday with us.
Yes. Kat Randall is a new member and she gifted a membership. So thank you.
Family hugs. We appreciate that.
When we said family hugs, we still owe a hug, I think, to Ms. Holmes.
I would happily give a a family hug right there.
Wow, Miss Twatty Waffle, member for 26 months. Oh, gee.
Twatty Waffle.
Twatty Waffle.
It's like one of my top 3 favorite screen names, monikers, whatever the hell they call it.
Whatever you call them. Thank you
Whatever. Oh
for
yeah.
your continued support.
Oh yeah.
Iceman, good evening. You know, guys, it's hard to watch a stream and watch my Wolverines advancing in the Big Ten tourney. Laugh out loud. Thanks for covering. Thank you.
Love it. Love it.
And then
Thank you,
last but
Iceman.
not least, LMP, where was the thin blue line for Kelsey? Yeah, that's what I want to fucking know.
That is a legit ass question. I'll tell
Legit.
you that. All right, we got some Venmos. I got to give some love for that real quick too. Kim, our daily $25 Venmo angel.
Thank you for your continued support, Kim. per
Floats
usual.
down from Venmo heaven and bestows another $25 on us. We love you, Kim. Thank you so much for your constant support. MVP level shit. And then Cindy, she says, a $10 Venmo. This is so disgusting. Maybe Kelsey got sick of his alcohol/drug abuse and lost her shit at the party.
That's
My
what I'm saying.
opinion. I think that's exactly what happened.
Yeah.
I mean,
And
she's
maybe there was some insinuation like, you think you're going to see you're going to get the custody of this baby without me when I can't trust that you're not going to get drunk and drop the baby, like something like that said, like in anger in the moment. And he was just like, oh, or repeated it to his mama. And they were like, okay, here we go. This is what we're going to do. We're going to devise a scheme.
scheming.
And I'd like to know, since when, even if you have permission to go in a house, can you break the door down? Can you damage the property?
And steal her laptop.
They know, they have evidence that he took the laptop. I mean, it's like,
There's no question. There were
and-
multiple crimes that were committed there.
it's just too much.
It's a fucking it's literally a burglary. As soon as he goes in there with the commission of a felony, it's a fucking burglary.
And as soon as he disengages the surveillance, where's consciousness of guilt now? Where the fuck does consciousness of
He
guilt stand?
stole her laptop. It's a fucking burglary.
Right, but if he says, oh, I thought I was perfectly able to do that, then why did you turn off the surveillance equipment?
And why did you steal her laptop and go steal her money and change beneficiaries and do all the shitty things that you did that were definitely illegal, friendo?
All right, is there any
All
more?
right, and then Deborah came through with the $15 weekly dono. Thank you so much.
Thank
Deborah.
you.
We love
for
you.
continued support.
And then wait, I think there were a couple more.
Well, Lexi two-time needs a hug, babe.
Oh, family hug. Thank you.
Thanks,
And
Lexi
then
two-time.
Alicia had sent us a $25 PayPal. Thank you very much.
Thank you.
Alicia, if there was a message on there, I didn't see it. If not, thank you very, very much for your incredible generosity. All right, guys. So we're definitely not going to do our Karen Reed stream today. This went almost 5 hours. That's what I
But
told
we
you.
were going to.
It's a wait.
It's
We are
all
definitely going to
prepared.
do it.
It's all prepared.
Allie did
Fully
all the
researched.
work.
Yes.
Oh,
On
yeah.
the amended complaint. We're going to be covering the amended complaint as compared to the motions to dismiss, and we'll give our legal opinion on whether we think the claims will survive a similar motion to dismiss on the amended complaint and the new allegations that's in the amended complaint.
Yeah, and if you know anything about our channel, we just call balls and strikes. So it's like it is what it is. And I even looked at it. Allie looked at it. I'm sure she has opinions, but we've been kind of avoiding Karen Reed like the plague. Just
We're
not
going to
so much
stick.
'cause I'm
We're
not
going to stick to the
interested.
law on it.
Yeah.
Whether we believe the allegations or not, that's not part of the legal analysis on a motion to dismiss the complaint. So the
Yeah.
court's not going to be weighing whether they believe it or not. It's just words have to be spoken, and were the right words spoken or not.
Yep. All right, mods, we adore you. You guys put in all the work this week. So much work. 5 days of trial, Saturday work. You guys are amazing. We love you so very much. Please, everyone, please, for the love of God, like, share, and subscribe. Spread the word. If you like what we do, let other people know. We think we have a
Yes.
pretty good channel. We really do. We think we put some pretty good thought-provoking content out there.
Pretty.
pretty good. And listen, because the reason that we need y'all here is because without you guys, I would quite literally just be an old man
Sitting around talking to his wife.
Boop.